Hi. So, good evening to all of you all. I welcome you all to today's JIGL marathon. Now, let me tell you what is upcoming for the JIGL marathon. Now, in the JIGL subject, there has been few amendments. I will be covering all those amendments as well. Okay. So, this marathon is going to be comprehensive. It's going to cover everything. If I'm touching upon a particular chapter, I will cover everything from it and in a fast-paced manner. So what happens is you will know that we are running through the entire chapter in complete depth with proper clarity as well. Okay, so whichever chapters I cover is going to be completed. Now I have put out my entire schedule for my particular marathons. Okay, so the entire sequence has been given. You can take a screenshot also. Now remember, this is not my only JIGL marathon. Before the exam also, like your exam starts around the 1st, so before that also I will be taking JIGL pre-exam marathon, where I will complete your full JIGL subject in the best possible manner. Okay, now let me just give you a small introduction about myself. I am Professor Zubair Jahangir. I am a company secretary and an advocate, and I have cleared my CS with multiple exemptions, including an exemption in JIGL subject as well. So I had got way above 60 marks when I was a student as well. So I was primarily very good with this subject, and that is why students also like this subject, because they're a very good thought process and the strategy that I use. Okay, so before I start, let me tell you a few things. First, to whether this marathon will be sufficient, this marathon along with my other marathon for JIGL which will come out, I will cover almost the full syllabus, and whichever chapter I cover it entirely. Okay, now first, what is the thing that you need to do? First, what in this marathon, what all materials I will be using. So there is a ICSI has issued a supplement or a amendment sheet. Okay, supplement sheet is there. So I'll just take you through the supplement sheet. So now this is the amendments for your June 2025 attempt. Okay, so they have given you these chapters in which amendment is there: constitution, interpretation. I will be covering the chapters in this marathons in the sequence that they have given. So I will be covering Constitution of India along with the amendment, because amendments has come. Interpretation of statute, civil procedure code. Then there will be another marathon which will be for the 3 criminal laws. So there will be one more marathon for JIGL in which I will cover all the 3 criminal laws together. Okay, that will also be done. Today I will be covering all these chapters: your Limitation Act, Right to Information Act, Technology Act. So 1, 2, 3, 4, 5, 6 chapters of yours I will try to knock off today. Okay, so 6 chapters, you sit through my marathon, everything will be completed. Okay, and including the amendments. Okay, one. Second, with me I have my JIGL scanner. Sir, what is a scanner? A scanner is the past. Especially I always recommend students to use our JT scanners only. JIGL scanner, it is there. Now what is this JIGL scanner and why we should use it of JT scanners? The reason is it has the past exam questions, including your December 2024 attempt solved paper as well. Okay, and the best part is it covers the ICSI model answers. Okay, so whatever ICSI is given as the model answer, on basis of that we have made this scanner. So how you can get this scanner? Very simple. You go to our website jahangirtutorials.com. In that free resources section, okay, if I just go through the website, you go to Jahangir Tutorials and you go in the free resources section. In the free resources section, you go to your executive. Around 2000 students have already joined the has already downloaded the scanner. All you have to do is click download now. All the scanners for executive and professional will be downloaded. So you can go ahead and do that. Along with that, the third thing is what I want to tell you is you need the scanners. It will help you clear your exams and it will also help you in the marathons. And the third thing is the dream batch. Okay, the dream batch also you can enroll. So what is a dream batch? On our website, again, if you go, you will get your the dream batch. It contains access to our paid lectures at a nominal amount, 299 approximately, and thousands of students have already joined dream batch from a long time. Okay, so you can go ahead and enroll if you are in whichever. If you are executive, then you can go for enroll now and click on that and enroll yourself. You will get access to the paid lectures for till your examination date. Okay, so the validity, all the details have been given. So it is valid only till this much time, but unlimited views and all your subjects. So you can go ahead, study from here as well, in depth as well. Okay, marathon is to give you a particular kind of boost and a quick revision of multiple chapters. Now, fourth is, remember that I want you all to have a mindset. Okay, the mindset is very important when you're setting for this marathon. First of all, I want a mindset of a person. So I have got an exemption in JIGL subject. If you also want an exemption, is first in the mind. So I want you to set your mind for exemption. You will study in a way that you will get an exemption. Just sit for my marathons, and trust me, after the exams you will say that everything that I have taught has come from my marathon only. Okay, because I cover everything and in a quick manner also. Okay, so detailed lecture, if you want, you can go to my dream batch. You just have to pay 299 rupees and you get access to our paid lectures till your examination, June 2025 examination. Okay, so make use of that. Now, exemption, I want you to have a mindset, and second mindset is I want you to be calm. Okay, I want you to be calm, relaxed, sit in a separate corner when we are starting this marathon. Take a book, pen, whichever chapters I'm going to knock off, it's going to be heavyweight chapters. So around 30-40 marks I will cover. I'll show you also which all I'm going to do. Okay, which all I'm targeting. So those we will do along with the amendments. Okay, so whichever is the amendments, I'm going to cover those chapters first. So let me take you through the chapters that I plan to target today and also the weightage of those chapters. Everyone's with me? Yes or no? Okay? Yeah. So in my marathon, this marathon, I'm telling you what all I plan to cover and knock off. Obviously in my other, just before your examination, don't miss those marathons. All my marathons, I'm almost targeting to complete everything. If today I can complete 6 chapters, 2-3 more days and I'll cover the full syllabus. Okay, your full syllabus gets over. So now today I'm taking heavyweight chapters. Okay, heavyweight chapters is Constitution of India. Pay attention. Is, though everyone knows, I will be teaching you all everything in a fast-paced manner. You want a book and pen written with you. It comes for around 15 marks in your examination. How many marks? 15 marks sure shot every attempt. So might as well we do it properly, touching upon everything. Second, the next important chapter we will do, I'm going in sequence of amendments that they have given. Okay, that only I'm doing. Second is interpretation of statutes, is 8 marks, 8 to 10 marks chapter. 2 doctrines they definitely ask. Even if you don't know any of this, you sit for my marathons now till the next time. 6 chapters I'm going to unlock. I'm going to knock off. Okay, so I need your presence with me, and as I told you, calm mind, separate place with a notebook, pen, and note down everything that I'm telling you. The third is again a 15 marker chapter, that is Civil Procedure Code. Then if you go to see your Criminal Procedure Code, okay, this Criminal Procedure Code can come for around 20 to 30 marks. 20 to 30 marks are actually, these are 3 chapters inside only. If you go to see CPC, it is your IPC, CRPC and evidence. So this I will be taking in another marathon. In one go I'll finish all the 3 chapters. So that also don't forget. So heavyweight chapters I'm completing. The next which I'm going to cover is your Limitation Act. This also comes for around 8 marks, 4 marks, 2 questions. It is there 5 to 8 marks. Then I will also cover your Information Technology Act, easily 5 to 8 marks, and even your RTI Act, 5 to 8 marks. Everyone's with me. So except for these two, I'm covering everything else. These two will be in a separate marathon altogether. Now, ready? The biggest heavyweight chapter is your Constitution of India. And Constitution of India, when you go, okay, when your amendment sheet, they've given you case laws. What have they given you? They've given you case laws. All these case laws they have given you. I have summarized all these case laws and I have covered it also. Okay, all these case laws which is there, I will be covering. Okay. So good to go. If you're ready, let me know. Let's begin with the marathon. 6 chapters we have for today. Okay, and 6 chapters in depth. Okay, so all I want is to be ready with me. Let's begin. Okay, everyone. And in the marathon, I will be touching upon things only that comes in the exam. Unnecessary things which do not come in the exams, I won't be touching upon. So whatever I'm doing is important from exam point of view as well. Okay, so everyone, I want you all, yes, don't worry, all of y'all, I will be covering this. I want all of y'all, whoever is there sitting with this marathon, I want you all to write exemption in the chat box. Exemption is 60 plus. If you keep a mind that I want to get 60 plus in my examinations, then only you will score 60 plus. So write with that and sit with me. You will see I'm covering everything. Okay. So everyone, I'm waiting for all of you all to write in the chat box exemption. Right. Come on. Every good. Okay. Great. Good evening. Great. Okay. Exemption in the chat box is our mindset, is our aim, and give me 4 hours. I will be completing all these chapters for you. Thank you. Shakti, Samir, great. Yes. Arivoli, hi. Karthik, Devika, Prajwal, great. Okay. Yuvashri, and thank you for sending the hearts also. Speed, excellent, excellent. All of you all are giving, great. Also, before I start, if you all can like the video also, it will be great, amazing, great. Let's start. Okay, so we start with our Constitution of India. Hi, so we begin with the Constitution of India. Now let's understand why is the word Constitution called for this book. Now the Constitution means, it comes from the word to constitute, means to constitute. Constitute means to form. The Constitution of India constitutes the basic laws on which all other laws will be followed. So that it constitutes the basic laws, basis on which the country will be governed. The country will be governed. Okay, simple. Now just a brief facts about the Constitution of India. Now Constitution of India is the most primary law. It is called as the mother of all laws because from the Constitution all other laws are formed. Now, the Constitution is adopted. I'll tell you, you can note down these dates. Adoption of the Constitution and 26th January 1950. So let's see 2 dates. On 26th November 1949, the Constitution was adopted. So the adoption was on 26th November 1949. The Constitution came into effect on 26th Jan 1950. So adoption was on 26th November and it came into effect on 26 January 1950. Now, if you see 26th November, the day it was adopted is also known as the National Law Day or the Constitutional Day. Now, coming to 1950, 26 Jan 1950, Republic Day is a public holiday which marks the country celebrates the date on which the Constitution came into effect. So, when the Constitution came into effect, now we became a sovereign country, no ruler could rule us. So, two dates, one is the adoption date and the other one is the Republic Day, okay, where it with effect from. On this date, it was brought into effect. Clear? So, two dates we can remember. Now, when the Constitution is started, it starts with a preamble. Okay, so they don't ask you the preamble, but we'll just quickly go through. We've always done it in school also. Okay, and normally it should be by hearted also, that we the people of India have solemnly resolved, that the people of India have decided to give to ourselves, that we are gifting a gift to ourselves, this Constitution, where India will be constituted, India will be made into a sovereign country. That means British rulers, no one can rule us. Sovereign country. It will be a democratic republic. What does a democracy mean? Government, people will be supreme. Government of the people, by the people, for the people. And what all it will do? It will try to give us justice, liberty, equality, and promote among ourselves, promote brotherhood called as fraternity. To in this Constituent Assembly on this 26th day of November 1945, the adoption date was there. We hereby adopt the Constitution. So again, Constitution was adopted on 26th November 1949. This same date is given in preamble also, in preamble as well. Clear till here, everyone? This much point is what we can quote. Now, let's see how many articles are there. So there are different parts of the Constitution. Okay, means the Constitution is divided into various parts. First, what we are required to know. Okay, as a exam point of view, we need to know two parts mandatorily. Okay, 2 or 3 parts you have to know mandatorily. That is part, anyone can tell me which part is the most important part of the Constitution? Which part is the most important part? So we will write in the examination 3 things. First is part 3, part 4 and part 4A of the Constitution. Part 3 is fundamental rights. Fundamental are the most basic rights. Right to right to speech and expression, right to your religion, etc. Okay, that is your Article 12 to Article 35. I hope you're noting this down, because this I want you. So we'll just do one thing, that whenever I put this point, okay, whenever I give a marking like this, red, okay, in red whenever I mark, I want you to note it that this you have to quote in the exam. Okay, this you have to quote it in the exam. So again, let's start. That part 3 is fundamental rights, part 4 are directive principles, that is Article 36 to 51, and part 4A is the fundamental duties given in Article 51A. So 110% exam question will be framed from these parts only, or definitely from this part one question has to come. Part 3, part 4, part 4A. Part 3 is fundamental rights, the next part is directive principles of state policy, and the part 4A is fundamental duties. Clear? So this is what we will learn. Now coming to the articles are also being given, okay, in part sequence. We will see when we come to it. Now, once we did the preamble, there are short exam questions from your Constitution. You can have big answers also. Now what I will give you is a short exam question. Short exam question. Ready everyone? Yes or no? I want you not only to learn it with me, note down, this is a short exam question from Constitution, most repeated exam question. I would say also it is a most repeated exam question. So which are those? Anyone knows which it is? There are three articles that come in. Okay. So the first one is Article 14, Article 19, Article 21, and the writs. Writs are given in your Article 32 and 226. You can take it from me that 100% one exam question will be framed from your. Okay, in your exam always it is there, writs. So let's see, now we will be covering it all in sequence. First we come to Article 14. So what is Article 14? Article 14 is right to equality. Right to equality. Article 19 is right to freedom. Right to freedom. Freedom of speech and expression, etc. Then comes Article 21, that is right to life. Okay. And in writs there are types of writs from which it can come. So each one we will see starting from right to equality. Now sir, if an exam question comes, write a short note on right to equality. Or they will give you the meaning and they will say elaborate. So what do we write? So I'm giving you pointers what you need to write. First of all, equality means what? The definition is the state shall not deny to any person. So Article 14 is telling the state here means the government. The government shall not deny to any person two things: equality before law and equal protection of the laws. Now, equality before law is an absence of any special privilege. For example, it should not be that if it is a politician's son, he gets an extra privilege. So, equality before law is an absence of any special privilege. And equal protection of the laws. Equal protection means what? When I say protection means, here they mean equal remedy will be given if the rights has been infringed. Means, so two parts, equality before law means nobody is superior, and equal protection means equal remedy. Equal remedy will be given. So for example, if a politician's son has done a murder and someone else, normal person has done a murder, punishment will be the same if the crime is the same. Clear? So that is it. Now, once you've written that, then you will write one line. Okay? You will write a line that we said that there will be equal, no special privileges, but the Prime Minister gets special privileges, women get special privileges, children get special privileges in law. So how is that coming in equality? So they said that, listen, now this second part will come, reasonable classification. Reasonable classification, that the state, those equal in the eyes of law will be treated equally, mean those who are equal, so equality among equals. But unequal person should not be like SC, ST, certain backward, you could say OBC. If government has said that these are certain categories, the special percentage can be given to them. Special benefits can be given to them. Why? Because if we apply the same rules, it will amount to inequality. So again, law allows reasonable classification. So reasonable classification is allowed. What does reasonable classification mean? That treating, okay, you are trying to make unequals among equals. So you give some benefit to make the unequals among equals. Okay? Next, the line that we will say that Article 14 forbids class legislation but does not forbid classification. So it forbids class legislation. Now this line I want you to write, and then we'll take a Summary of Article 14. Class legislation means to make a law without lawful justification. Means if I am saying that why Prime Minister is getting Z class security, if there is a lawful justification, that is allowed. Okay, so it does not forbid reasonable classification. What does reasonable classification mean? Reasonable classification means making special provisions for based on which is lawfully justified. Okay, so whenever we make a reasonable classification, means we are making special provision based on lawful justification. So if lawful justification is there, that is allowed. Law does not forbid reasonable classification, it forbids class legislation. What does class legislation means? Means making a law without applying your mind. Now this same thing was held in a case law. Okay, what was the case law? Two case laws were there. That was Justice Tendulkar and your state of West Bengal versus Anwar Ali Sarkar. This has come in the past exam question also. That they said that, listen, you're trying to give some special provisions. It is allowed if you're having some intelligent differentia. Means there is a difference that can be seen. Prime Minister and others. Women are subject to more harassment. That is why you're giving. So if there is a intelligent difference that we can see, it will be allowed. Classification is permissible on two conditions, and we are trying to achieve an objective. So intelligent differentia, and we are trying to achieve an objective. For example, women get special rights in certain trains, buses, public transport, right? They get. So can anyone question it? Answer is no. Why? Because it is based on a intelligent differentia. Proper difference, we can see that women need protection because they can be subjected to harassment. Second, we are also furthering an object. Object is what? Protection of women. Okay, so this is there. That's it. Your Article 14 is done. Similarly, I told you same points have been read in Ram Kishan Dalmia versus Justice Tendulkar. That two conditions, same, intelligent differentia, object. Mathematical accuracy is not needed. Like you cannot be a mathematically accurate, this is separate. Intelligent differentia on basis of this is fine. Even a single person can qualify as a class himself. Example, Prime Minister, PM, Prime Minister himself alone, one guy is there, he's a separate category can be there. That is it, okay. Now, one case law. Now we are seeing one case law, exam case law. Okay. Now we are seeing a exam case law. Pay attention. Okay. This was asked in the past exam question. PQ. Past exam question. Now what happened is, you tell me. The state, in this case, the Supreme Court held that valid classification has to be a nexus between the senses and object. Intelligent differentia and object should be there. Supreme Court said that making a district-wise distribution of seats to state medical colleges on basis of the population of a district was held to be void. Mark it as super important. Super important. That in the case of P. Ranjandran, it was held that district-wise distribution of medical seats. For example, if this is the state, this was a state of, okay, so this was a state. They said that the medical seats will be distributed on population, on basis of the population. So if here there are more people, we'll give 30 seats here. There are less people, we'll give 2 seats here. There is, very less crowd, we'll give 1 seat here. So this kind of a difference is against Article 14. Against Article 14, and it is held why. I want to know why. Why? Now imagine, what if 31 students here are extremely hardworking and deserving. So what will happen? Unnecessary, due to your difference of population, you cannot deny a candidate. Give it on basis of merit, is what they have said. So in This case it was held that it did not have a intelligent differentia. Now we are done with Article 14. What did Article 14 talk about? Your definition, then reasonable classification, then your class legislation, then the case law, Justice Tendulkar, Anwar Ali, and it is done. And one Raj, this case law is also a state-wise distribution. Let's go to the next one. The next article which is extremely important is Article 19. What does Article 19 talk about? It is a right to freedom. Now, freedom is given here in Article 19.1. Now, pay attention to how I am teaching you. Article 19.1 gives you the rights. Certain rights are given. Okay, 6 rights has been given to you. In 19.2, the restriction is given. The reasonable, restrictions has been given. That means no right is unlimited. Where there is a right, there will be a restriction also. In 19.2, what is given is the restrictions. Let's see. Okay. Now, Article 19.1. If you see very interestingly, can you spot a difference? Can you spot a mistake out here? Article 19.1a, B, C, D, E, F, G is there, right? Now, in this, I would write that is 1, 2, 3, 4, 5, 6, 7. But here what they have given here, that there are only 6 freedoms. Only 6 freedoms. So, 1 has been repealed. Can anyone tell me which right has been removed? Which right has been removed and was deleted by which amendment of the Constitution? Very good. So, the sixth one, right to acquire property. So, you do not have a mandatory right to acquire property. For example, Ambani will buy full of Maharashtra. Okay, there will be someone else who will buy full of everything. So, acquiring land is not your fundamental right. Okay, done. So, let's see. First, and there is a sequence given. A is first they allow you to speak. You can say your mind. Then a little more right. After speaking, what you want to do? You would want to assemble without arms. Without arms, ammunition you want to assemble. Now you've made an assembly. Now what you want to do? You want to form your own friend circle, group of association, trademarks, trade unions, anything you want to make a association. Now you want to move freely. Then you want to reside anywhere, and in the end you want to practice any business or profession. This I want you to learn along with the sub rule 19.1g. 19.1g is practice any profession or trade or business. Let's begin. So what is the sequence? First I am allowed to speak. Then I am allowed to assemble any place without guns, etc. No weapons. I am assembled. Then I can make my own union with people. Then I can move freely. Then I can reside. After moving, I want to reside somewhere. And then in the end, I want to practice any business or profession. From here, I want you to know this is Article 19.1a and 19.1g. These two. Okay, we will see when we come to it. Now, can anyone tell me what is the second Article 19.2 talking about? Tells you about restrictions, that no particular article or right can be unlimited. So obviously it will be subject to certain restrictions. The restrictions are given here. For example, you cannot speak in a way that will harm friendly relations. You cannot affect the sovereignty of India, security of India, friendly relation, cannot be indecent, cannot do a contempt of court, cannot do defamation, that is, or incite any offense. So just learn this. Almost for each of them, this restriction is there. Okay. Now, all of them they will give you. Now, certain case laws we will see, which is specific to So two articles I told you in this that you need to know. Can anyone tell me which one? I told you in article 19, which talks about right to freedom. What it talks about? Right to freedom. Okay. It has article 19(1) A and G, which is important from exam point of view. Article 19(1) A, that is speech and expression. And what is G talking about? It is talking about your right to practice any business and profession. Concept clear? Now we will see some case laws with respect to that. Some landmark cases. Okay. So from here, it was held in Maneka Gandhi versus Union of India that it has no geographical limitations. It carries even to not only India but abroad also. For example, if a citizen is there, he has a right to speak. He wants to go out of India and speak. Can the country stop him? Can any authority stop him? Answer is no. The speech is throughout the world. Second, when you see Indian Express versus Union of India, many times you will see about press. See, which is the fourth pillar of India? Fourth pillar is your media. So media should be free, machinery should be, the press should be allowed. Indian Express is a newspaper. So what are they saying? That the press, newspapers play a very important role in democratic machinery. Okay, in democracy they play a very important role. They allow you to write anything that you want to write. This is what they have told. In Romesh Thapad versus State of Maharashtra, freedom of speech and expression was held that without a free political discussion, no political education is possible. Okay, so without having a political discussion, you cannot ever educate. That is also given. Okay, with respect to press release only, that a press is allowed to discuss political aspects also. In freedom of speech and expression, they also say that you have a right to broadcasting as well. So freedom also includes a right to communicate through audiovisual ways. Okay, so if the cricket match is being relayed, etc. Now, from exam point of view, which case law can come in your exam? That is your Bijoy Emmanuel versus State of Kerala. Very, very important case. Okay, it has come in the past exam question also. I'm covering every single thing. Okay, everything from the Constitution of India will be covered and 15 marks will be in your pocket. First, in this what happened? The students did not want to sing the national anthem. Allowed or not allowed? What do you think? So the Supreme Court held that the students that did not commit any offense, there was no law in which the fundamental right under Article 1 could be curtailed. So it was held that if the students are there, they remained silent. They didn't sing the national anthem. It is permitted, it is within their right. Okay, so you cannot force anyone to sing or speak at all. It might be morally questioned, but not a criminal wrong or not a wrong under eyes of law. They say it is his right, he doesn't want to sing now. Done. Okay, so in this case what happened is the school expelled certain students. Why? Because they did not sing the national anthem. They said no, you cannot do this. It is their right to remain silent. So right to speak includes right to remain silent. Concept clear? Perfect. Let's move ahead. Okay. Then again, press has the same part, that they are subject to reasonable restrictions, etc. Even censorship. Now, nowadays you see so many movies are there and it gets censored. So can they say that my right to freedom of speech and expression has been violated because the movie has been censored? So the answer is that the pre-censorship is among the reasonable restrictions. Okay, it is, and reasonable restriction is given under Article 19(2). Clear? So if a movie is being censored, it is allowed. You cannot say that my freedom of speech and expression is being violated. Why? Because freedom of speech has reasonable restrictions as given under 19(2). Now, in this case, you can write it with respect to a RTI Act. Okay, in your respect to your RTI Act, what happened is right to information. Only if you get information, only then you will speak. Today, if I tell you to write a essay on the nuclear deal, okay, which or non-proliferation treaty, if you don't know only anything about it, you will not be able to write. So in this case, what it was held that you will only speak if you receive information. Therefore, in order to speak, receiving information is very, very important. So in this case law, it was held that one will not be able to express themselves unless they receive information, and therefore Right to Information Act was enacted that the citizens get access and information about government records. Only then they will be able to speak and express their opinion. Okay, that's all we've done. Now directly we come to the next important thing is Article 19(1)(g). It talks about freedom of trade and occupation. Now, first, okay, now same thing we had seen above also, that if you are there, that is subject to reasonable restriction. Some additional restriction is you need to have the qualification. Okay, you need to have the professional qualification. For example, if a doctor wants to do an operation, he needs to clear his MBBS. If a company secretary wants to, if a person wants to sign as a CS, he has to clear these, he needs to clear the technical qualifications. Okay, so you cannot practice any business or profession unless you get the license for it. So getting a license is a reasonable restriction. Let's see. One very, very important case which has come in the past exam question also, which is your Bombay Hawkers versus Municipal Corporation. And this was a case of Article 19(1)(g). It was about hawkers. Okay, the Bombay Municipal Corporation, they said that they refuse a license of the hawkers to start their business on the streets. Now, you see all these street people, they are there, they open their shop and they start selling. The BMC, the Municipal Corporation, they said move everything, go away. So the hawkers went that to court, saying that their fundamental right of doing business is violated. So law said that listen, the Supreme Court held that listen, you have a right to do, but you cannot disrupt other the public streets. You cannot take it as a private thing. So no person has the fundamental right to carry on the business causing nuisance, annoyance or inconvenience to public. This was held by the Supreme Court, and they said that the BMC was, the municipal body was correct in moving aside all the hawkers. Then came another case law again of Article 19(1)(g). Okay, this is, so I am doing all the case laws which are important from exam point of view. Article 19(1)(g). What does it talk about? Similar thing, Chintamani Rao versus State of Madhya Pradesh. Now Madhya Pradesh government said that so there was a lot of people in the village doing BD business, smoking that BD that is there, they wanted doing that business. The Madhya Pradesh government said you cannot do BD business during agricultural season, you have to do agricultural activities only. Allowed or not allowed? So then all the people said that listen, it's my right, I have a right to do whichever profession I want to do. I don't want to do agricultural business, I want to do BD making. So allowed or not allowed? Can the government force you to do agriculture? Tomorrow government will say don't do CS, do only agricultural activities. Allowed? So it was said that this kind of law is illegal. Law was only struck down that no person residing, that the prohibition which you done is unfair, unreasonable. Okay, same thing was there, which was there here. Now coming to one more thing, right to do business. Okay, you have a right to do business. Now imagine state government as a monopoly in certain things. Okay, constitutional right of state monopoly. Pay attention. I am saying that, like, give me an example where the state has monopoly in the business. In any thing where the state has monopoly. Okay, state as monopoly. Let's see. So the first thing is the state government has monopoly in railways. In railways, yes or no? Railways. Now the state government has monopoly, right? So I will say it is versus Article 19(1)(g) that I have a right to do my own business. I want to do business of railways. So allowed or not allowed? Will the state monopoly be kept held and the business you will not be able to do? So answer is it is allowed. State monopoly, if it is being mentioned in a specific law, then it is a coming in reasonable restriction. Okay, so what is the rule? That certain monopolies for certain businesses are given in favor of the government. It is completely justified. States can create monopoly in their own favor and it is held to be reasonable under the reasonable restrictions. So we are done with Article 14. We are done with Article 19. Now we are doing Article 21. Article 21 is very simple, that right to life. No person shall be deprived of his life or personal liberty except with the procedure made by law. So can you kill a person? Answer is yes. Procedure of law, proper hang to death process should go on, then it is allowed. So no person can be deprived of his life. Nobody's life can be taken except with the procedure by law. Or his personal liberty. Liberty means the right to freedom of movement. We can put a person in jail also, but only with a procedure established by law. In Kharak Singh versus State of UP, it was held that right to life includes the right to sleep. Right to life is a very wide right. It includes a right to sleep also. So maybe if a prisoner is there, he is being not allowed to sleep, etc., not given internal proper environment, that is wrong. So right to life is given even to prisoners, etc. Okay, let's see. So multiple, it's a very wide right. Right to life is the most important right, which like giving a life, right to go abroad, right to privacy, right to legal aid, right against custodial death, right to live in healthy environment, right to fair trial. All this is coming in right to life only. Now, one right was given, which is a right to adopt a child, is a constitutional right given in Phillips versus Jones Salvia. Okay. Now we are done with Article 21 also. Now Article 21A, very important, very important. Okay, it is, let's mark it in red. Okay, it was introduced by an amendment in 2002. It says right to education. Okay, so if you see, education is free, government schools are there and they cannot charge any money. It is shall provide free and compulsory education. It is the duty of the government to give compulsory education to all the children from 6 to 14 years, okay, as determined by law. Okay, schools must have qualified teachers and basic infrastructure. This was held in Environment and Consumer Protection versus Delhi administration. So in Article 21A, what did they say? That they should also have proper facilities. In state of Tamil Nadu versus Shyam Sundar, held that the right of a child should not be restricted only to free education but should be extended to having quality education, as we saw. In Fahim Shireen versus State of Kerala, it was held that the right to internet access is also a fundamental right, very important. So quality education, right to access and right to have proper qualified teachers also, very important to get a right to access. Okay, now so we are done with the three important articles, 14, 19, 21 and 21A also. Now we are seeing article your fundamental duties. Fundamental duties are given in Article 51A. Okay, very simple. Right to abide by the constitution, uphold the sovereignty, integrity, defend the country, promote harmony, okay, preserve the rich heritage of the country, preserve the environment, develop a scientific temper, safeguard the property, try to get excellence in all the spheres that you do, and give a opportunity to the child. So these are your duties of the fund of the citizens. Now understand, see, fundamental rights are given, and now as a citizen also you have a duty. Duties are given in article number 51A. Very, very important. Let's see. Then I told you 4 things out of which exam it comes only in the exam. One is your, so important from exam point of view is article 14, 19, 21. Okay, 21, and the other one is what? Article, your writs, and writs are given under article 32 and 226. Okay, now we will see what is the meaning of writs. Okay, types of writs. Clear everyone? So market is important again. You have to know the types of writs also. I'll tell you all the pointers that you can build your answer. First, what do you mean by the term writ? So writ is an application. What is it? Writ is an application. Okay, filed in, it is an application filed in High Court or Supreme Court. So in no other court can a writ be filed. It is filed in High Court and Supreme Court, and it is stating that certain fundamental rights under Part 3 of Constitution have been violated. So if you can tell the government that you have fundamental rights which are there in your Part 3 has been violated, you will file an application in the court that is called as writ. If you go to High Court, it will be under Article 226, and if you go to the Supreme Court, it will be under Article number 32. Clear? Let's see. Now they have given you 5 kinds of writs. How many kinds of writs they have given you? One is habeas corpus, mandamus, prohibition, certiorari, and quo warranto. All I will explain in one go only. Remember, your prohibition and certiorari is linked with each other. So prohibition and certiorari is linked with each other. Let's see. Habeas corpus means to bring the person who is illegally detained. Why bring him? To check legality of his detention. Okay, so habeas corpus means to bring the body. So if a person has been illegally detained, he can write to the court that, listen, I have been illegally detained, I have done nothing in this thing, and still I have been kept in jail for long time. So habeas corpus will be filed. Court will bring the person, check the legality of his detention. If they find that it is detention is illegal, they will secure the release of the person. Okay, so habeas corpus, the objective is to release person who has been illegally detained. The objective is not to punish the person who has illegally detained you. Okay, next comes to mandamus. Mandamus means to command. Who are we commanding and who is commanding? So command is coming from and to it's coming from a higher court to a lower court, or to a lower authority, or we can say public authority, to a public authority. And what command it is? That do your public duty. So let's see. So if your BMC is not doing, if your municipal body is not doing a good job, they are not giving you clean water, so, or the roads are not good, you can file a mandamus and tell that we've written continuous application to the officer. They are not listening only. So then the court, High Court or Supreme Court, will order. Command means they will order the public officer or public authority to do their public duty. That's it. Now let's come, this prohibition certiorari I'll tell later. Quo warranto, what happens means, it means by what authority are you holding a public office? For example, there is a post, a railway officer post has been given to a politician's son. So what happens is, any person who feels that he should have got that office, because he had got more marks, he has better experience, but that due to corruption he is giving to his own family member. So any person who is aggrieved, who is not happy, he will write an application to the High Court or Supreme Court for quo warranto. That quo warranto means the court will ask him, by what authority did you get it, how did you get your job, show me, and they'll look at the detention. So first thing, it is only for public offices and can be filed only by a person who was aggrieved and who is claiming to that office. Now let's see what is difference between prohibition and certiorari. So now we're going to see the difference between prohibition and certiorari. Okay, let's see. Very simple. So if a lower court is passing a erroneous judgment, so maybe they don't have jurisdiction and still they have taken the matter, or the lower court cannot take up the matter but still they took up. So two things can apply. One is prohibition and certiorari. So if order pending, then prohibition will be filed, that is it will be prevented from passing a wrong order. So higher court issues to lower court a order, we are prohibiting you from taking up the matter because you are pass a erroneous judgment, you don't have powers to do it. Family matter took up a company case, or company law, NCLT, National Company Law Tribunal, thinking of an income tax matter. So they say you don't have the power, any judgment you give is going to be wrong. So if order is not passed, we are stopping you. And if order already passed, so order passed, then we will squash the order and replace it with a new order called as certiorari. Concept clear? All the 5 writs? Yes or no? So prohibition is to prevent and certiorari is to squash. Quash means set aside. So we will set aside a wrong order which is already passed. Clear till here? Now let's go to the next important thing, which is called as the structure of the constitution. Very important, can come in your examination also. So I'm going in the flow of importance and repeatedly asked exam question. So one of the thing is structure of the constitution. So whether our constitution is two kinds, okay, we want to know whether our constitution is unitary or it is federal. Let's understand. So constitution of any country could either be in two forms. Either it could be federal or it could be unitary. Okay, constitution could be federal or unitary. In federal, what happens, there is a distribution of powers, and in unitary, what happens, the powers are united, it is in common control. Okay, so there is a superior, he only decides, all the powers are united. So then now they are wondering that whether Indian constitution is federal or it is unitary. So they said that, listen, it has the features of federal also. We'll see which all federal features it has. It has features of unitary also. So it is both. So therefore we are somewhere in the middle, called as quasi-federal. What are we called? We are quasi-federal. Quasi-federal means partly both. We have features of both. So we'll see which all features we have of federal and which all features we have of. So these features of federal we have. What is that? That dual government, distribution of powers, the constitution is supreme, independence of judiciary, written constitution, and written procedure for amendment. So all these features are of federal. Okay, all these features are of federal. So we have a dual government, central government and state government. Powers are distributed. Between whom? Center, state, powers are distributed. Constitution is supreme, nothing can go against the constitution. So all these are features of federal, we have all of this. But we also have powers of unitary. Okay, so we also have powers of unitary also. So the unitary features. So when you go to see the features of unitary system, we have single citizenship, we have a precedence rule that during emergency, like we saw in maybe India and Pakistan, we have a war, all the powers comes to the president, so that is also there. Residuary powers, anything which is not there comes in the central government, so that also is the rule. It is the features of unitary. And judiciary, so Supreme Court is supreme decision, so all this is the features of unitary features. So we have a single citizenship, right? Like if you go to see, Canada has dual citizenship, you can have Portugal as dual citizenship, you can have two citizens of citizenship of two countries, but India you cannot. Precedent rule is there, that in any external exertion, all the president gets the full powers. Okay, so all these features also we have. Now we come to another important thing which can be asked in the exam, very very important. They have asked also, when can the parliament make the laws on something given in the state list? Pay attention. Your parliament means we're talking of union government, union or central government, and here we talk about state government. So let me explain. Okay, powers of government is distributed. Okay, that means the central government has certain powers, the state government has certain powers. Done. Okay, normally in normal scenarios, central government cannot make laws on which state government is making the laws, and state government cannot encroach upon central government's power. So power cannot be crossed. Each one has their own powers. Clear? Simple. But in the Constitution of India, there is sometime this, we are talking of the Union Parliament. Which Parliament? Union Parliament. There is an exception when the central government can make laws for the state. So there is exception to this rule, exceptions, that where central government can make laws for state government. Can you tell me when? Give me the points, only headings I need. I don't need anything else. I need only the headings. Okay? When it is. So let's see. First, second, third, fourth, fifth. When the central government, union, can make laws for state government. So first, let's say if we have a international agreement, we have an international treaty. So India has entered into a treaty with Mauritius, Indo-Mauritius treaty. Then obviously Gujarat cannot say that I will not agree to this treaty. It's for the whole of India. So whenever we are entering into any agreement with a state, with another country, we make a full agreement. Second, whenever there is a war, external aggression, armed rebellion, we'll see these words. Okay, whenever all of this happens, automatically the central government will become the power, and they can make for all the states. So no country, if a war has been declared, obviously it will be declared by the central government, and all the states will have to follow. Next, if two states themselves, they come and they say that make a law for all of us, for both of us. So if the two state government are only coming and they tell the union government to make for me, so we'll make. Then comes breakdown of constitutional machinery. If at all the state government cannot run the country as per the Constitution of India, what is happening is, when the state government is not able to run as per the Constitution, then the central government can take over. Precedent rule can be declared. And the last thing is, when the Rajya Sabha members, where all the people from all the states are come, they only pass a resolution. Rajya Sabha members, they make a resolution that we should have a central law, or we should have a law for the state. So why it is allowed? Because in Rajya Sabha, all the people are coming are elected people only. Okay, so let's see. Headings we do, it's enough, but you write down the article number. So in national interest. So this is about the Rajya Sabha. Okay, when two-thirds of the Rajya Sabha member say that in national interest we should make a law, okay, which will be applicable for the whole of the country or part, then it will be made. Second, proclamation of emergency. Imagine if a emergency is declared where we have a war. I told you what all word did I use? War, external aggression or armed rebellion. Automatically the president's rule can be declared. If a state cannot follow as per the constitution, then the central government will take over. Two or more states themselves, they have gone and told make a law for us, or when we are entering into a international agreement. So beautiful, if you've written all the points, your topic is done. Okay, now we'll see some of the definitions. Definition of state. Now when I say, you can ask, for example, let me give you an example where it applies. If a state of Maharashtra, there is a bus driver, okay, of the government only, government bus driver, and he caused an accident. Who will pay compensation? The driver will pay or the state will pay? Who will pay? Come on, tell me fast. If the government authority, if the government person has done a violation, who will pay? Obviously the state will pay. Now you can also file cases on the state. So what is the rule? First you have to understand who all can come under the definition of state. So state includes, so whenever we are saying to understand whether, let's say BCCI, if there's something wrong in the BCCI, okay, the cricket board, can I file a case on the state? Answer is no, because BCCI is a private organization, not a particular state. So for the state, it should either be set up by the state government, central government, or by the local authority, or it is under the control of the government. So if I see any particular company which is under the control of government, or the government has a right to appoint, or the government has funded, or it is completely a government organization, then only the state can be held liable. Okay, let me give you another example. If a tree fell on a person, he was walking and the tree fell on him, he can file a case on BMC, which is ultimately the state. Why? Because it is a authority of the government. Okay, so the local authority include municipal bodies, etc. Okay, that is why you see in railways, if there is a railway accident, the government gives compensation. So there was a case whether BCCI is a state. In Z Telefilms versus Union of India, they said that it is not under Article 12 because it is not controlled by the state government of India. Okay, it's a private body, IPL, etc. that comes. Now, very, very important to identify something which is, okay, to identify whether a thing is a instrumentality of the state. What is the word used? Instrumentality of the state or no. If I want to know that is this connected with the state, if it is, I'll file a case on the state only. So we will look at whether did the government set up, did the government fund it, did the government do anything. Then is the share capital held by the government? LIC, imagine if LIC money is not given, I will tell that it's a government organization. Okay, so the financial assistance has been given, or whether the like BEST or the railways enjoys a monopoly over the business, then we can file on the case state only. Okay, deep and pervasive state control. If there is a deep and pervasive, means a widespread state control in that organization, we will say it is a particular instrumentality of the state, means it is a state, instrument of the state, funded, etc. It has been given. Now understand one thing, they have given you something called as directive principles of state policy. Okay, remember, directive principles of state policy are coming under part 4 of Constitution. These cannot be enforced, be enforced cannot be enforced in these cannot be enforced uh, in court. Means if the government cannot fulfill the state what has been given here, you cannot file a case on them. So these are not actionable in court. So let's understand what is this state policy. So these are just some value principles, value, ideal, best principles that has been given. Okay, that the state should follow while preparing their policies. So these are some principles which the state should follow while making their own policies. So state should endeavor, should try to do it, but they cannot be forced to do it. Very, very simple example is giving free education for all ages, equality, or giving good standard of living. Okay, giving a clean and healthy environment, setting up villages. So this will the state should try, but cannot be forced to do it. Okay, because this is extremely good principles that have been set up. Now you'll see Article 20. Okay, Article 20. Now Article 20 has 3 sub articles. How many? Article 20 has 3 sub articles, 1, 2 and 3. Okay, 1, 2 and 3. Now what does Article 20 talk about? I want you to just read it up and tell me till I just get my charger for my laptop. Article 20, 1, 2, 3, I want you to note it down. What it is, fine. Fundamental duties can be enforced. Answer is yes, because it's a duty that you have to give. Okay, mandatory. Good question. Okay, read it. I'm just coming in 2 minutes. Okay. So now, am I audible and visible? Quickly. Is my screen also visible? In the chat box. Quickly. Okay, great. Let's see. Article 20, 1, 2, 3. First, what does the first one say? Okay. Article is a protection against ex post facto laws. Ex post facto laws. Your 2 is about double jeopardy, and third is about self incrimination. So I want you to note it down, okay, with me. Very, very important. 3 articles, 3 doctrines will also get knocked off now. So first article, this is against ex post facto laws. Protection from ex post facto laws. The other one is double jeopardy. And the third one is right against self incrimination. So self incrimination. Now pay attention to what they are saying, okay? So first is your easy one. I'll first start is Article 20, right against self incrimination. Means no person can be forced to give a statement against himself. Okay, so no person can be forced to speak against himself, give evidence himself. So even in front of the police officer, if I give any statement, I cannot be forced to. It's not taken in evidence in court only, because they know that sometimes the police beat up the person so much. So it is a right against self incrimination. Incrimination means self punishment. Why should I myself go and confess on anything? Why should I punish myself by giving out the things? I have a right to remain silent. Double jeopardy is like no person shall be vexed twice for same offense. So for example, this will come in your civil procedure code also, that if I have done something wrong, I cannot be punished twice for the same thing. So once if punishment is done, matter closes. And now coming to the most important is ex post facto law. Ex post facto means what? Constitution was there could be some pre-constitutional laws, and there can be some post-constitutional laws. Everyone's with me? Okay. Ex post facto could be pre-constitutional laws and post-constitutional laws. Now in pre-constitutional laws, first let's do the post one, that no, if the constitution came into effect, okay, came into effect year on this date, all the laws before the constitution, so before consti and after consti, after the constitution. So if any law was there existing before the constitution are called as pre-constitutional laws. And anything which is now any law is being passed, it is called as post-constitutional laws. So post-constitutional laws cannot, so no law can be against the constitution, cannot be against consti. So no law passed today can be against the constitution. Simple. No law can be passed today against the constitution. That's given as a this part, okay. So that is given as a post-constitutional law, given under Article 21 subpoint B. So if I tell you that no law can be passed against the constitution today, so that is your post facto law, that today no law can go against the constitution. Now coming to your pre-constitutional laws, that laws which were existing before the constitution. So they become invalid. So any law which was before the constitution become invalid if they are against consti. So any previous law before the constitution came, if they are against the constitution, they will become invalid. Finish. Now from this part, okay, 21A, there are certain doctrines that will come. Okay, there are certain doctrines. So the first doctrine is doctrine of severability. Okay, and the other doctrine is called as doctrine of eclipse. Doctrine of severability and doctrine of eclipse. Pay attention. If any, so this, can you tell me that these two doctrines come from which article? Article 21A, which says about pre-constitutional laws. It talks about pre-constitutional laws. Pre-constitutional laws, one says that it says that any pre-constitutional law which is against the constitution will be invalid, void, ineffective, etc. Now from here, two doctrines are there. One is doctrine of severability, and the other one is doctrine of eclipse. So what does doctrine of severability says? That to cut. Severe means to cut. So if an act is there, if an entire act is there, okay, now imagine an entire act is there, and from the act only some portion is invalid, and everything else is valid. So if a portion contains a valid act contains valid portion as well as invalid portion. So as per doctrine of severability says that you just sever this part, just cut this part, and the rest of the act will remain valid. This is only if the act can operate independently after being cut. Okay, so imagine if a person is there, you cut his hand, he might still survive. But if I cut the head, the person cannot survive. So if you remove so many provisions that the act only becomes invalid, cannot operate by itself, then the full act will be repealed. So when the full act will be repealed, when you cannot cut, or when you cut and the full act will, the remaining part, the valid portion is not big enough, so the full act will be repealed. Doctrine of eclipse, what it says, that if a act is invalid, let's say an act became invalid due to constitution. So any act which became invalid due to constitution, they are not dead. They don't become dead altogether. They don't just die forever. What happens is, if constitution restriction is removed, if the constitution which restriction it had, it removed it, so the act will become automatically valid. Act becomes active again. So what does eclipse means? It means to come ahead. So if this act is there, due to constitutional restriction it became invalid, so it does not die. If the restriction is removed by an amendment act, this act will become valid again. We will see with examples. So is the concept clear till now? Yes or no? Let's see. Okay, ex post facto law. So first we will see article here. Okay, so that was 13, which we will see when we come to it. Article 13, which I was relating to. Here let's see ex post facto laws. Okay, one second. Okay, great. So now let's see ex post facto law. That no person shall be convicted of any offence, okay, except for violation if at the time of the commission of the offence nor shall be given a greater penalty for the time which it was in force. So again, this we'll see this, these two things were there, was article 13. We'll see when we come to it. Okay, now let's see this ex post facto laws. That if an act was done here, okay, an act is done here. Now you did an act, illegal act or illegal offense you have done, then you cannot be subjected to greater penalty. Okay, if future there is an amendment and the penalty has been increased. So if I go to just frame the sentence, no person shall be convicted of any offense, no person shall be convicted of any offense except for violation of the law at the time of the commission of the offense. So when you did an act, that time it was not an offense, so you will not be held liable. Okay, so let's take an example. If I take an example which was valid earlier, now became illegal. Let's say having diesel cars. So operating with diesel cars, it was very much valid in earlier, but now if it has become invalid, then anyone who was operating earlier is allowed, because at the time when they were doing the act, it was not illegal. Nor can be they subjected to greater penalty. So let's say if a person was subjected to the act was punishable by 3 years. Later when the punishment was increased, you cannot be subjected to greater penalty. Okay, so no person shall be convicted of an offense except if it was violation at a time when he had done it, or nor can he be subjected to greater penalty than what would have been inflicted at the time of commission of the offense. Okay, double jeopardy, self-incrimination. Then comes article 22, talks about rights under the ordinary law and your preventive detention. Now what are we seeing? We are seeing your protection against arrest. If a person has been arrested, he will be informed why he has been done. He has a right to consult a legal practitioner and he will be brought before the magistrate in 24 hours. Constitution, article 22. Now if someone has been detained for preventive detention, what does preventive detention mean? That he is not committed the offense. He is suspected to have committed an offense. So means detention of a person without trial. The objective of preventive detention not to punish but to prevent him from doing it. Okay, so here if you have a security reasons, etc., you have a information, you can detain him. Same grounds will be there in article 22 also. Some points will be same, that he will be communicated why he has been arrested. He has a right to receive legal representation is also given, and some extra points has been given. What is there? That such person cannot be detained for greater than 3 months. If you want to do that, then you have to have an advisory board. So max preventive detention can be done for 3 months unless a special board has approved it. More time. Then we come to delegated legislation. What is the concept of delegated legislation? Let's see. Okay, now delegated legislation. So a legislation means a power to make a law. Who makes the laws? So parliament makes the laws. Now what happens is the parliament cannot sit daily and make amendments in the laws. So what they do, they delegate the power. What do? They delegate a power to an authority. For example, the GST Act is made by the Parliament. GST Act is made by the Parliament. Okay. So, but day-to-day amendments, etc., cannot be made to them. So, what happens is the GST Council is there. GST Council is there. They have been the delegated authority to make the day-to-day amendment. Delegate means to transfer some powers has been given to them. So this council, when they make any law, it is called as delegated legislation. So delegated legislation is what? When a delegated authority makes a law, that law is called as delegated legislation. This delegated legislation cannot supersede the parent act. So this can be called as the parent act. This will be called as the subordinate act. Okay, so it must always be within the framework only. Now let's see. Delegated legislation. What do you mean by delegated legislation? It's a subordinate legislation. The main act is GST. The subordinate laws is there. Okay. Need. Now why the government does not pass, the parliament does not pass? Because they have a lot of pressure of work. Technical. GST is a very technical thing. IT is a very technical thing. Unforeseen emergency situations. If they have a lot of emergency, etc. So a parliament cannot sit every time. But a GST council which is dedicatedly made can do it. Okay. There are 5 kinds of subordinate legislations. First is executive legislation. Okay. So where you give the power to the executive. Okay. The executive means the police, etc. to make their own law. SEBI is an executive authority. They will make their own law. Judicial delegated means the judiciary can also make their own laws. So parliament has their own laws, etc. That has also been framed. Municipal body, when they make the law, is called as municipal legislation. Okay, autonomous legislation is universities. Okay, where they operate by themselves, they can make their own rules for attendance, etc. Colonial legislation is colonies. So mostly this is there in other countries. Okay, which is their colonial legislation where they have colonies and they themselves make the law. So that's a colonial legislation. This we have already done now. Article 13. Okay, laws 13(1)(a) we have done. Pre-constitutional laws and post-constitutional laws we have done. That nothing should go against the constitution. From that we had seen doctrine of severability. Article 13 I told you all. Okay, severability means to cut. If the invalid portion can be cut, then it will be allowed. If the invalid portion cannot be cut, then the full act will be removed. Then we had doctrine of eclipse, that the act does not die. Moment the restriction is removed, the act becomes active again. Okay, now come to ordinance making power. Now what is the ordinance making power? Ordinance means a temporary emergency law. A temporary law. Okay, ordinance is called as a temporary law. This temporary law, only 2 persons in India has the power. One is the governor. Governor is for the state, and for the country, for India, it is the president. So for India or for the country. So emergency temporary law can be made by the governor for the state only and for the president for whole of India. President is made is under Article 123 and this is under Article 213. Okay, Article 213 and this is Article 123. Clear? Now when I say temporary means will it be this law will be valid forever? Answer is no. Normally Parliament makes the law. Only when the Parliament is unable to meet and emergency situations arise, then an ordinance is passed. So it will only be valid for 6 weeks. Now we will see what is it. 6 weeks. Validity is only 6 weeks from the date of reassembly. So moment the Parliament assembles, from there 6 weeks only it will be valid. So for example, the President made the law ordinance, Governor made the law, it will be valid for moment the Parliament sits and plus 6 weeks. That much only. If they have repealed or cancelled this law earlier, then that will be end. So whichever is earlier. Immediately needed, Parliament cannot be set, it has a temporary effect. Temporary means 6 weeks only for both President and this thing. Okay, President and the Governor. Now we come to another doctrine which is called a doctrine of pith and substance. Pith and substance means what? You look at the essential character. Essential character. Okay. So what happens is, this was the case was there of Praful Kumar versus Kulna. Okay, what it was held that the powers of the state government, okay, the powers of the government is divided. Okay, state government is there, and you have your central government. So the powers are very much divided, but sometimes some matters come right in the middle. So the central government has its own powers, state government has its own powers, but in some matters there are overlapping powers. So that time we have to see which government could make the law. So to do that, we will look at that matters pith and substance. Pith and substance, that we will look at their essential character. If we find that this essential character is of the state government, then the state government will be allowed to make the law. So an example, a classic example has been given, that with respect to sound amplifier. So this, the speakers, etc., which was there. The central government said that the loudspeakers should not be there beyond 10 p.m. Example. So law was made for sound amplifiers by the state government. Whereas the central government said, how you made for broadcasting is in my domain. So we say, yeah, amplify the voice is coming in broadcasting. So now question came up that whether the state government can make the law on sound amplifier, because broadcasting is in the central government's domain. But then the state government said that I purposely did it for maintaining peace and sanity, which is in my power. So loudspeaker should not be there because it disturbs the peace and sanity. For that the rule was made. So when we saw that the main law was made to fulfill one of the powers of the the government, it was allowed. So let's read that and finish it. See, public health and sanitation was under the state government. So they said they made a law on sound amplifier saying that public health is involved. That is why we are doing loud noises can disturb the health of people. So the central government said that listen, the broadcasting is in my domain. The Supreme Court argued that the object of the law was to prohibit unnecessary noise. So when we look at the essential character of the law, it is public health and not broadcasting. This was held in Chawla versus State of Rajasthan. Okay. Then we come to colorable legislation. Now let's understand what is colorable legislation. So colorable legislation means a law which is illegal, is passed under the color of being legal. Okay. The law which is illegal but has been passed under the color of being legal, so it is colorable. It looks very confusing. So what sometimes they happen, they lift the corporate wheel. How in company law we lift the corporate wheel? Here we looked at the law that something which you are not allowed to do legally, you cannot find a route and do it. So what is not allowed directly, you cannot do indirectly also. Okay, so no power, legislature has no power to do something which is beyond their competence. So remember we had this kind of electoral bonds issue which was there. So government issued electoral bond. They said that we will not, anyone can give us donation and the names will not be disclosed. So the Supreme Court said that this is colorable legislation. You are taking donation and you will favor that company. Quid pro quo will be there. One moment you relieve, let the public know. Why hiding that? So then that entire electoral bond scheme was declared illegal. Government passed it under the color of being legal. Okay. So a legislature passed giving it a color of constitutionality, okay, and trying to achieve something which is illegal, which you cannot do. Such law is called as colorable legislation. It is illegal. So in this Kameshwar Singh versus State of Bihar, what happened is they said that we will collect from the landlord, from the tenants. The government will collect 100% unpaid rents, and they will give 50% to the landlord. So the landlord or the zamindar said that, listen, you are showing that you're trying to help me by giving me 50%, but I should get 100%. So this entire law, Bihar Land Reformed Act, was declared unconstitutional because it came that you're trying to rob the landlord of the rent. Some part you are taking, some part you're giving them, when 100% should be given to them. Okay, then we just go through the articles numbering wise. Article 15 is that the state shall not discriminate only against any religion, etc. No state shall be subjected to any, no citizen shall be subjected to any disability restriction with regarding to access of shops, well, etc. Okay. Article 15, 3 and 4, government can make special provisions for women and children. Let's understand. You know, there is a problem of casteism in India, that you are from lower caste, I am from higher caste, etc. All this is there. So it is inhumane. Okay. Because humans are equal. But due to this casteism issue, some people are looking superior, some people are looking inferior. So in olden days, they used to say that this person is from this caste, he should not be allowed to enter in the temple, he should not be allowed to have water from here, or any other kind of religious discrimination is there. So they used to not allow. So that has been removed by Article 15. Okay. Prohibition of discrimination on the grounds of religion is no citizen shall be subjected to any disability to access any public restaurant or use of well, etc. Then comes with respect to jobs. Even in job, the government cannot discriminate on basis of religion. But however, for both these cases, women, children, special treatment can be given. Okay. Now this is the case law that has been introduced. Okay. Now, Secretary versus State of Karnataka. Very, very important that the Supreme Court held that equality in employment is a basic feature. Okay. And core principle or Article 14. So you can learn it in State of Karnataka versus Uma Devi. That having in employment no discrimination on basis of caste, religion, gender, place of birth, etc. should be there. It is very, very important. Then comes article number 17, talks of abolition of untouchability. So untouchability is abolished, and any act that is done is also abolished, and it is caused it's a punishable offense. Article 18, abolition of title. So getting this except no title, not being a academic distinction or a military, so that is allowed. CS you can add, CA you can add because it's academic. Military title is there, that is also allowed. Okay. Apart from that, no person can receive any kind of title. No citizen shall accept it from any other foreign state also, like foreigner giving Sir Bradman, that all is not allowed. The awards for Bharat Ratna, Padma Vibhushan and all of that is national awards, would not amount to article number 18. So that all is allowed. Okay, so all these articles we have done. All this has been covered. Okay. Now we come to article number 368 and Keshwanand Bharti versus State of Kerala. Very, very important. The amendability of the fundamental rights. The amendability of the fundamental rights. Okay. Let's see. First thing is, can the fundamental rights be amended? Yes or no? I want to know from you. What all will you write if it comes? Okay. What all will you write if it comes? Okay, cool. So, first thing, it is given in Article 368. What it says, that on amendability of the Constitution, that the Constitution can be amended. Okay, in Keshwanand versus State of Kerala, okay, it was held that a concept of basic feature, that if you want, you can amend the Constitution how much ever you want, but you can never amend the basic features. And what is the basic features? The basic feature of the Constitution is rule of law, supremacy of the Constitution, writs, judicial review, your federalism, secularism, all this has been identified as. It was held that no part of the constitution, including the fundamental rights, was beyond the amending power. However, the basic structure could not be abrogated even with a constitutional amendment. So they said that no part of the constitution was beyond the amending power of the parliament. Parliament can make any kind of amendment, but the basic structure of the constitution cannot be amended. Okay, then is the High Court and Supreme Court. We have the subordinate courts. Separation of powers. So if you see, the powers have been separated by the legislature, executive, judiciary. The legislature is the parliament, executive the police officials, and the judiciary are the courts. So 3 organs of the government. Then law making process is there. So every every bill is first introduced in the parliament, gets both the approval from both the houses, and then the president assent, and then it becomes a act. Now we talk of parliamentary committees and 2 parliamentary committees that are there. Okay, so parliament committees help the parliament in discharging their functions. There are 2 kinds of parliamentary committee. One is ad hoc committee and the other one is standing committee. Ad hoc is only a special purpose, only whenever they need a committee to be made. For example, a committee could be made for GST, a committee could be made for AI rules. So that is an ad hoc committee created. They are there only for the specific purpose. After that is dissolved. Standing committee are permanent and regular committees that are constituted, and it is always there. Then we come to bills. Okay, and bills, difference between ordinary bills and money bills we will see. Okay, so a bill, if you see, now we have income tax bill. Once it is get approved, it become income tax act. Similarly, there is a data protection bill. Once it is approved, it becomes an act. So bill is a draft statute. Once approved and assented by the president, becomes an act. Okay, now we'll see what is a money bill. First, money bills are dealt in Article 110 of the Constitution. The bills are talking about tax and how you get the expenditure. That's it. So 2 things they talk about is taxation and public expenditure. So money comes in through taxation and where the money will be expended. That is called as money bill. So what all is covered under money bill? Bill is presented in the Lok Sabha with the prior permission of the President of India. It is ratified by the Speaker of the Lok Sabha as money bill. So the Speaker will ratify it as approve it as a money bill. What does the money bill talk about? Only these things: taxes, then government borrowings, consolidated fund of India, where the money will be used, expenditure, and receiving the money, how all money will be received. That's it. This is all Article 110, which is calling a money bill. So tax and expenditure. Now we come, when we add a few more elements in it, it becomes a finance bill. So a finance bill is wider than money bill. It includes money bill. It includes money bills also. Okay. Now, what is a finance bill? In addition to above, they also talk about fine, etc. That's it. Okay. So a finance bill will also talk about imposition of fine, duties, demand of payment, services. For example, government is giving any security to any private company, so how much fees will be. That is restricted above is taxation. Here it is other sources of income also is covered, like fine, etc. Dubai charges so many fines. So finance bill is under article number 117. Okay, it talks about the finances and could be taxes, government expenditure, borrowings, revenues, everything. So most wide concept. Then we come under article 301, trade, commerce and intercourse in India. Okay. So article 301 says that very simple. Okay, so all these articles that we'll be doing are very simple, that any person can do business freely in throughout the country. Okay, so Article 301 provides that you can do trade business throughout the country. Finish. Okay, there is no restriction, but that does not mean you can do illegal activities. The objective is to remove geographical barriers within the country. However, you can put some taxes, that all is fine, it's not called as a restriction. Then comes Article 302, power of to impose restrictions on the Parliament may impose restrictions if it wants in public interest. So first one says you can do, second one they say we can impose restrictions if we want, Parliament. Third says no discrimination between the states. Can one state say that no, you are from this state, that state? The internal fighting between states is not allowed. Neither Parliament nor any legislature of a state have a power to make any law discriminating between one state to another. So if I say from Gujarat, if it comes this much tax, if anyone else is coming from Tamil Nadu, this much tax. So that is not allowed. Discrimination between states not allowed. Everyone can do free business is what they are writing. Article 304, restriction on trade between states. So the legislature or this may impose. Now this can be done on imported goods. Okay, and reasonable restriction can be put. So if it is coming from imported, obviously we put taxes. That all is allowed, and some kind of tariffs, procedural differences can be there if it is imported good. That's all is allowed. Then 305, Article 305, also very simple. Article 305 talks about that whatever we say that you have a right to do business throughout the entire country, you can do business. That is Article 301. They are saying that doesn't mean that we cannot restrict all the business completely by saying that only the state can do the business. So nothing can affect the powers of a state by creating a monopoly. So if the government wants, they can create a monopoly like they have done in railways. They might say in a post that only the government can do it, nobody else. So then you cannot say that I have a right to do business. That's it. We have already seen that it comes in the reasonable restrictions. Now, case laws which is there, which are newly introduced. Okay. Now, market is important. So when you see this is your sheet. Okay, this is your supplement sheet of 2025. Which case law they are writing? Satyendra Kumar versus CBI, and the other case law is your Kishore, then your PHR Invent Education Society. So 3 case laws they have added. Let's see, we'll do it and finish it off. So first case law, Satyendra is there, and what is the thing that bail is the rule and jail is the exception. The Supreme Court said that normally we should always give bail, and jail will only be given as an exception. Very rare cases we will give. The government identified that a lot of times procedural laws under CRPC, which is now BNSS Act, so is not being followed. So the facts of the case were they found that there is a pattern that accused were arrested and sent to custody, and procedure is not being followed. So they said that whenever there is a misuse, the bail should be given. So the Supreme Court has given the following directions, that Government of India may consider introducing a comprehensive bail act. They have said that in this act that you should make a bail act. They said the police officer duty bound to follow the act. Okay, any failure to follow the act means the person bail must be granted. So if they find procedural laws defects, they should grant a bail. In CBI versus Kishore, what it was held, that the Supreme Court held that when a law is declared unconstitutional for violating fundamental rights, it is deemed to be void from the very beginning. So there was this DSPE Act, Delhi Special Establishment Act. It was invalid from its very insertion. So it required approval of CBI to arrest, investigate senior officials. Now imagine CBI has to take approval if they want to investigate senior politicians, officials. So this itself was struck down by the Constitution, by the Supreme Court, saying that the act is unconstitutional. So if anything is unconstitutional, means it is, the act must be there for 3 years, 2 years, and then later it was found unconstitutional, then it becomes void from the very beginning. Okay, so any act, so in the fact Subramaniam Swamy versus CBI, they said that this act itself is violating Article 14, right to equality, that CBI has to take permission to investigate seniors. So this looks like corruption. Law was passed. So they said that this entire thing is void ab initio from the very beginning. And the third case law is PHR Invent Education Society versus UCO Bank. The Supreme Court clarified that the writ petition under Article 226 is not maintainable when effective remedy exists unless it falls under a judicial exceptions. So what they said, that normally if you have a remedy under law, then you cannot file a writ petition. Writ petition should be filed normally when you don't have any other remedy, or if it is falling under some extreme gross wrong happening with you, which is, then it will be allowed. So Supreme Court clarified that the High Court reiterated that the should not entertain petition if a proper remedy exists, except if something wrong is done. Okay, statutory acts contrary to the statutory authority acts contrary to the statute, fundamental violates fundamental rights, when repealed provisions are used to pass orders, provisions which are repealed and order has been passed, or where the complete violation of principles of natural justice. So if all this is done, then they will take up. Normally they will say that if you have a remedy, please go and take there. Okay, with this we have completed the entire chapter, including all the amendments and the past exam question for Constitution of India, and your 15 marks, 15 to 20 marks has been secured. That is it. Now we'll start with another chapter, which is your second chapter, which is given here, where, which is the thing here, we'll be doing your interpretation of statutes, which is the next chapter we'll be starting off with, is interpretation of statutes. We'll cover it with all the ICSI amendments also. So in an interpretation of statute, they have also added a case law. They've added this case law. Okay, interpretation of statute. They've added the authority of advance ruling versus Akavani spilling mills. So this also I have added in my notes. We will be doing that also. Okay, so interpretation of statutes. So now next chapter that we are starting is interpretation of statutes. Good to go. Till now, if you are there, I would request you to first like the video, share it among your friend circle also, and in 10 minutes we will start with the chapter. So 10 minutes we start with the chapter. Clear till here? Just like the video. Let me know if you have made notes while doing this chapter. Okay, that's it. So let's begin in 10 minutes. Hi guys, am I audible and visible to you all? Okay, so guys, am I audible to everyone? Yes or no? Simply in the chat box, we will start and complete this chapter in 45 minutes. Okay, so I want all of you all to put in the chat box whether I'm audible and visible. Yes or no? And is my screen visible to you all? Okay, just give me 40 minutes. I'll complete this full chapter for you. Full chapter, and full chapter means actually full chapter I'll be covering including the past exam question and the amendment sheet. Okay, so for this much at least you can give me a like, and if possible please share it with your friends as well. Audible and visible in the chat box, I want everyone to put audible and visible quickly. Okay, thank you so much for the heart, it feels good. Great, waiting for you all to put into the chat box. Okay, so the more responsive you are, the better it is for me to start. I'll be covering the full chapter. Yes, full chapter entirely will be done. Not a single question can come outside than what I'm doing. I'm covering the full chapter, including the past exam questions and the amendment sheet. So in the chat box, I want you all to put audible and visible. That's all. Audible and visible in the chat box. And yes, how much ever I'm doing, only that much. So note it down. Okay, great. Let's begin. GDG Ananta, thank you so much. Let's begin. Hi, so now we begin with a chapter which is called as Interpretation of Statutes. Now let's break down this lesson called as IOS. Interpretation means understanding. What does interpretation mean? Means to understand. And statute means a law, an act passed by the parliament. So sometimes while the law is there could be some kind of a confusion. Now remember, I will be using some words. Okay, there could be a confusion in reading the law. Some English terms I wanted to write it down first only. Confusion means ambiguity. What does confusion mean? Ambiguity. We will not use the word confusion, we will use the word ambiguity. Okay, so ambiguity is there sometimes in any laws. So because of which we feel that we need to interpret the law. Now obviously we need interpretation experts. That's when legal experts, jurists are called, who are experts in law. They are called to interpret the law. There are some principles of interpretation. There are some rules for IOS, interpretation of statutes, that need to be followed, which we are going to study. Okay, so the very first rule is called as the primary rule. The rule for interpretation is called as, the first rule is called as primary rule. The primary rule could also be called as a literal rule, or sometimes they also call it as a golden rule. What does it mean? Today, if I don't understand any particular word, where do you go? You go to the dictionary. You go to the grammatical meaning of the word. So, now listen to the language people find it difficult, whereas it is very simple. Just listen to how I am speaking. Okay. If any word, phrase or sentence Okay, so according to the primary rule, any word, phrase or sentence should be understood as per their natural, ordinary or popular meaning. So whichever is the normal dictionary meaning, we should use it. Finish. Unless it leads to absurdity. Absurdity is another word that we will use, which is called as stupidity. We will not use the word stupidity, it doesn't sound correct. We will use the word absurdity legally. So 2 English words I have increased your vocabulary. You will write ambiguity and absurdity. Ambiguity means confusion and absurdity means stupidity. So normally we should apply the dictionary meaning, literal meaning, popular meaning, unless you feel that no, it is not correct. Okay, done. Now the literal rule is the words, what was the word, sentence or phrase should first be given their dictionary meaning. Okay, if the meaning is plain, clear and unambiguous, that should be used. But we should not use, interpretation should not be given if it is making other words or provisions redundant or ineffective. Now another English word, sir, called as redundant. Redundant means ineffective, making it stupid, etc. So we should not give any meaning. Normally you use dictionary meanings. If it is good, you use it. If it is fitting properly, you use it. If it is not, then you don't use it. Simple, that is what they have given you. That is the first rule. Normally they say that keep in mind that every word is important and the object of the act has to be fulfilled. Okay, that's it. So we are done with the first rule. What is the first rule? The literal rule, that give the literal meaning from the dictionary, the popularly understood or the grammatical meaning, unless it gives to absurdity. Now the second rule is an extension of the first rule, that if it leads to absurdity, then we should apply the second rule. What is the second rule? Rule of reasonable construction. You will have to see the legal, the Latin word also. Okay. What is the meaning? Rule of reasonable construction. That norm, now how you will build it, understand. Normally, start with the literal rule first. Normally, words, phrases and sentences should be given their literal meaning, their grammatical meaning, their popular meaning, unless it leads to absurdity. Full stop. That's the first rule. Now you write, if it leads to absurdity, then don't give the literal meaning, don't give the dictionary meaning, modify the meaning of the word to give a reasonable construction. Modify the meaning of the word to give it a reasonable construction means understanding. So when we don't use the dictionary, then we apply some logic. That logic is called as reasonable construction. So whenever normally we give the ordinary meaning, but it does not serve the purpose, that time courts are allowed to modify the meaning of the word. That is called as reasonable construction. Okay, so what do? We try to modify to give a sensible or reasonable meaning. Okay, and we should always keep in mind the subject matter and the object of the act. While doing this modification, we should keep the object of the act in mind. Okay, so a provision of law cannot be so interpreted to separate it completely from common sense. We have to read it with common sense. So we have to modify the meaning of the word. So this you will understand with the help of example. Okay, giving an example of knee versus cap. Now pay attention. Knee versus cap. I want you to note, quoted in the exam also. In this, the word interpretation of the word stop was used. When we saw the dictionary meaning, the popular, the common understanding of the word stop means to halt. How much time, etc. is not been given. How much time, it is not given. Halt means even a short halt is a halt. So as per the Road Traffic Act, it was said that a person should stop after an accident. So a person, what he did, he stopped for 10 seconds and he ran away. He said, see, read the word dictionary meaning where it is written that we stop for some time. So then the interpretation of the word stop came. The law said that, the judge said that, we need to interpret the word stop. That we cannot give it the dictionary meaning because then it is not fulfilling the object of the act. So we will modify the meaning of the word and we will say stop here in this act means to stop for reasonable time where proper inquiries can be done. So we modified the meaning of the term stop. Okay. So the driver caused an accident, stopped and then moved away. It was held that the court applied the reasonable construction and the driver had not stopped for a reasonable period and that is why he was penalized. The next similar case was in assessing authority versus Patiala manufacturers. It says possession. Say that you should be in possession of a registration certificate. What it had told? That the Act, Punjab General Sales Act, said that you should be in possession of a registration certificate. Now question came up with the word possession. What do you mean by the term possession? Government came, raided your office, they said show me where it is. I said I don't have it, I have it in my other office or I have it in the home. They say no, possession means actual possession. When we go to dictionary, when you go to the dictionary, it means actually having it, actual possession. So they say no, we cannot just catch him anytime and say you should be continuously with the registration certificate. What the law meant, we will now modify the meaning, dictionary meaning, and say the actual possession means what? You must have obtained it and whenever we give you in reasonable time, you should be able to bring it up. So now even when you're driving and driving license you don't have, it is not an offense. You have certain time to present it. Okay, so that is there. So they modified the meaning of the term possession, saying that you should have taken it, not actual physical holding it that time. So we finished literal rule, we finished the reasonable construction rule. Concept clear till here? Now we come to the third rule. The third rule is completely different. Rule of harmonious construction. Harmony means what? It's an English word. What does the word harmony mean? It's an English word. Harmony means peace, peaceful, okay, peaceful. And construction means to construct, to make, to create, or we could say peaceful interpretation. Construction here we could say interpretation. Interpretation, okay. Now pay attention to harmonious construction. Whenever there is a head-on clash between two provisions of the same enactment, then interpretation should be given such that effect can be given to both. Sir, what do you mean? Pay attention. Whenever there is a conflict, there has to be a head-on clash, a direct fight between two provisions, provision 1 and provision 2. Provision 1 and provision 2, there is a conflict between two provisions of same enactment, means same act. Then you are brought in to interpret. So will you say that 2 is right or you will say 1 is right? What you will say? So normally when there is a fight, what do we say? Don't worry, you are also right. Don't worry, you are also right. So in harmonious, that's a harmonious interpretation, that both of you all have your own. I understand your viewpoint, I understand your viewpoint, both are correct. Similarly, in any act, if there are two sections which are conflicting, which are opposing each other, then we should try to interpret in a way that effect can be given to both, that both can be operative. However, that does not mean that you do wrong interpretation. Okay, so we should try. Okay, so when two provisions cannot be reconciled, then they should be so interpreted that effect could be given to both. This is called as trying to peacefully do as much as possible. So this is to avoid head-on clash. Okay, so we try to harmonize. So now we'll see an exact classic example of Sharma versus Krishna Sena. It was versus Article 194 versus Article 19(1)(a). Article 19(1)(a) is about speech and expression. You can speak. Whereas Article 194 is about you can't speak what is going on in the parliament. So it's about a parliament privilege. That whatever is there in the parliament, you cannot come and leak it out. Now, head-on clash between two provisions. One is saying that there is a parliament privilege from speaking, and the other one is saying that you can speak. So then the interpretation was harmoniously done that listen, freedom of speech and expression is there. However, it is subject to certain reasonable restrictions. 194 is a reasonable restriction example. Finish. So both were given effect that both are valid. That's it. harmonious construction. Clear till here, everyone? Then we come to a extremely beautiful little another rule of interpretation. That rule of interpretation is called as Ednis generis. Normally, when you don't know this rule and you try to read it literally, everything will go bouncer. I'll read it first, then you'll see everything goes bouncer, and then I'll explain with the help of an example. Then this same thing will become very simple. Let's read. Ednis generis means of the same kind. What it means? Of the same kind. When certain general words follow a specific words of a distinct category, the general words will have a restricted meaning of the same category. Did you understand even one line? Let me explain. See, an example was given that example of AG Brown versus AG versus Brown. Okay, now note it down. AG versus Brown. Section 43 of the Custom Consolidation Act said that you are prohibited to import, means you cannot import arms, ammunitions, gunpowder or any other goods. What did they say? Arms, ammunition, gunpowder or any other goods. Interpretation of this word any other goods came into force. So they said, what do you mean by any other goods? So interpretation of this, does it mean ice cream? Does it mean a pen? Does it mean a comb? They say no. Any other, I'm saying any other means any other, right? They say no. See, what happens is, this is a general word. This is a general word, very loose word. But this general word is coming after certain specific words of a certain category. So all these are arms, ammunition and gunpowder are special words of a category. Explosives, right? All these gunpowder. So then this general word will have restricted meaning. Now the general doesn't mean an ice cream, doesn't mean a ball, doesn't mean animal. This general word will have a restricted meaning to the category of the special words. Means this any other goods here means anything like arm, ammunition, gunpowder, gun can come here, rifle can come here. Okay, all those things related to arms and ammunition will come here. So how are they framing the sentence? That if any general word is followed, means it is coming later after certain special words, then the general word will have restricted meaning of that category. Finish. Concept clear? Yes or no? Let's read it now. So Ednis means of the same kind. So this generis means category. So same category. So that general words will be of the same, is considered to be the same category of the special words. So when certain general words, etc., any other goods follow a specific word, so specific words were then this later this came on. These special words are of a distinct category. Then the general words will have restricted meaning of that same category. Okay, but certain conditions are there. These are specific words are coming first, then the general words come later. The class is not exhaustive and this must be applied with great caution. Finish. Concept clear? Yes or no? Then we come to the next beautiful rule, which is called as mischief rule or Hayden's rule or purposive rule of interpretation. This is from General Clauses Act. I want you to mark it down. Many times students don't know what is purposive rule of interpretation. It is mischief, Hayden, same rule, same thing, same answer. Question can come, write a mischief rule. They can tell you write a Hayden rule, write a purposive rule. Okay, let's understand mischief rule. So here I'll give one line and then I'll explain that line. The objective of an interpreter is to advance the remedy and suppress the mischief. So what is my role as an interpreter is to suppress the mischief and advance the remedy. So suppress the mischief and advance the remedy. Now let's understand how we do it. So first thing is, I want you all to tell me in the chat box that if there is a Companies Act 2000, Companies Act 2013 was there. Before 2013, which act was there? I want you all to put in the chat box. Please participate, tell me. Okay, so which was there before the Companies Act 2013? Quickly, everyone. Very good. So it was Companies Act 1956. So this was the old act. This was the old act, and this is the new act. Okay. So now old act must be having some mischief. Old act must be having some mischief, some defects. When I say mischief, meaning defects. For example, they didn't talk about online video calling. They had a lot of didn't have technology related aspects. 1956 had certain weaknesses. So we have to go first to the previous act. I'll go to the previous law. This is the first thing that I will do. If I want to understand Companies Act 2013 better, what is the thing I have to do? I have to first go to the previous law. Second, I will go that what was the mischief in the act? What was the mischief in the act? I'll see that Companies Act, these defects were there. Then I will see that what was the remedy provided. What was the remedy provided? And fourth, I will see that what is the object of the new law. Object of the act. Once I go to the previous law, then I will understand the new law correctly. So to interpret, they are just telling that go read the past act also. Okay. So if today I don't understand GST law, I can go back to excise law, I can go to the service tax, this law, etc. So mischief rule is done. It was, why it is called Hayden? Because it was brought in the Hayden's case. And it was a UK act, so they used to call the judges used to be called as barons of exchequers. Barons of exchequers are called as, in UK they were called as like the judges. So they said that four things are to be considered. What was the common law before the act, previous law? What was the mischief or the defect it did not do? What was the remedy provided, and what was the true object of the act or the remedy? This is what is the mischief rule, Hayden's rule, or purposive rule. And Sora Devi said case also, just a theory that they said that Hayden's rule is applicable only when the words are unambiguous, okay, and capable of more than one meaning. See, common sense. If anything is clear, we will apply the rules. We will apply the rules only when there is ambiguity, confusion. I told you, few words you have to put into your vocabulary. We are done with the main rules. All the main rules are done. So first was the literal rule. Second was the reasonable construction. Third, we had done the harmonious construction. Fourth, we did the Hayden's rule, and fifth we did the which was the other one? Mischief rule, Edinus generis. Very, very good. Okay, so these were the rules that we have done. Now there are some other rules also, which are the very, very simple ones. So they put in the other rules of interpretation. First, expressio unius ex exclusio alteris. Just remember this line, that express mention of one thing means something else is excluded. Okay, so express mention of one thing implies the exclusion of the others. If I tell that in this room there are all boys, that means girls are not there. So express mention of one thing implies that others are excluded. For example, if I say that the fundamental rights, if I tell you that the Article 19 says that rights are available only to citizens. So express mention is there of what? Only to citizens. Means who is excluded? Means non-citizens cannot gain these fundamental rights. Simple, that's the rule. Then comes another thing, contemptio ex postea optimia ex focima in lege. Okay, so just remember the word contempria. Contempria means of the same time. Like you and me are contemporaries, we are living at the same time. we and Gandhiji is not at the contemporary because he was at a different time, not alive when we were alive. Now, just from the contemporary, okay, what did they say? That if you want to interpret any law, if you want to interpret any act, understand any act, then become a contemporary. Go back to the time when the law was being passed. Go into the minds of the framers. So what do you have to do? You have to go into step into the shoes of the makers of the law. That will give you a clear understanding what they had felt around that time, what were the issues, and then give the interpretation. So because the law was passed at that time, so that time what they were thinking, you have to go into the history. So contemporary, become a contemporary, so you will understand the law better. That time what all arguments were there, parliamentary arguments were there, study that. So let's see. This magazine means that the best way to give meaning to a document, the best way to find the meaning, is to read it as it would have been read when it was made. The best time is to read it as if the contemporary of that time would have been reading it. Statutes should be interpreted as they would have been read at the date when it was passed. It is important to step into the shoes of the maker. Then comes nostris socius, means associates. Can I say that you are known by your friends? If all your friends are stupid, can I say that you are also stupid? Meaning that a person is determined, the value of a person, meaning of a person, understanding of a word is determined by its associates. So if a word is here, then you have to look at the previous words and you look at the succeeding words and the accompanying words. Okay, so what has come preceding and what has come succeeding. So if I don't understand a meaning of a word, I read the full sentence, I see what were the words before it, what were the words after it, and then I apply the meaning. So this is called a nostris socius. We all do this. Okay, a word is known by its associates. In other words, meaning of a word should be known from its accompanying or associate words. The meaning of a word can be derived from its previous or succeeding words. A word in a statutory provision is to be read in connection with its companion words. So you have to read it with its companion. Simple. Nostris socius. Read it with its companions, its associating words. What words are coming before, words are coming after, and then try to get the meaning. Then comes to strict and liberal construction or beneficial construction. This has, all of this has been, all what I have done, all has been asked some of the other time in the exam. Now we are seeing difference between strict and liberal construction. Understand. Construction, what did I tell you? Construction means interpretation. Okay. Interpretation. So interpretation for criminal laws, or taxation are always strict interpretation. Which interpretation is given? Strict interpretation. Whereas for other laws or beneficial laws, okay, like labor laws, example, labor laws, always liberal interpretation is given, because here the person is getting benefit. Let's understand. When a person, okay, strict means you have to punishment will be given only if all the conditions are strictly followed. So strict means all the conditions of law, all the exact statements of law, all the requirements of law, all the essentials of law should be fulfilled. Then only penal penalty will be put, or this is mostly for fiscal laws will be put. So for example, if I have to see that should I put tax or not put tax, I'll ask that, see if it fits exactly. If even one little bit of doubt is that, don't put penalty or don't put the tax. So it's a strict interpretation that we don't want to put lot of penalty on people. A liberal interpretation is where we say even if all the essentials are not there, just give it a loose interpretation, and because my benefit will come here. So here if I have to see that should I give benefit of 1,50,000 or should I give a benefit of 2 lakhs, which I should give? Okay, fine, yeah, even if they are not fulfilling all the condition, still give him benefit of the higher one. So we are giving a loose interpretation. We are saying okay, this or that condition is also not fulfilled. Still, why? Here you are getting benefit. So extension of benefit can be given. Extension of penalty they will not give you. They will say only if you are fitting, then only so only if it is a bottle tight case, then only penalty or tax is put. Clear? Simple. So strict interpretation is always there for which laws? Penal or this. If a reasonable interpretation can, if there is a reasonable interpretation which will avoid the penalty, then you will not have penalty. So if we give, if any condition not fulfilled, it will be penalty or tax will not be put. Criminal laws, etc. Are given strict interpretation, means unless the accused is found guilty strictly as per the provision of the law, he cannot be punished. Okay. Taxation, monetary are also covered here. Liberal interpretation means a statute with purpose to confer a benefit. Okay. Then such benefit is given to the interpreting statute liberally. We try to extend as much benefit as possible. Okay. Labor and welfare laws are given loose interpretation also. Okay, then case was there that the question whether the minimum wage to the Minimum Wages Act does not define the minimum wage, it cannot be taken into did not take into account the employer's pay. It was held that act is beneficial and must be construed in favor of the worker. So any beneficial law is always seen in the benefit of the laborer, worker, etc. Now we come to aids of interpretation. Now understand one thing, there are two aids of interpretation. See, aids means help. Okay, aids in interpretation. Now in interpretation of a statute, you can get within the act help you can get, or from outside the act, benefit can be given. So within the act, if you go to see, it is called as internal aids. Internal aid means within the act only you have certain things for interpretation, like your definition clause, like your object clause, like your preamble, like your schedules, like your sections, chapters, examples, all given within the act only. But only when the internal aids are not sufficient, then you will say that listen, even after reading the full act in depth, all the examples, all the illustrations, everything, rules, etc., still there is, I can't understand. Then you will go outside the act, which is called as external aids. What it is called? External aid. So when internal aids are insufficient, then you move ahead to the external aids. Okay, like use a dictionary, use a foreign judgment, use a maybe you will go to a previous law, etc. Okay, any parliamentary letters, etc. So very, very simple. Internal aids means like your title. So title means the object of the law. Companies Act 2013 made a law to consolidate the law relating to companies. It's a title. In the act only you will give in section 1 only. So normally this is a section 1 provision only. Normally the preamble is also given, like in a constitution gives you a window into the minds of the framers. A gist is given. This is also generally in the section 1. Okay. Section 2 clause is called as definition clause. Okay. So your interpretation clause is always in your section 2. Most of the act it is there in section 2, which is the definition clause. It define only different meaning of director, meaning of company, etc. So in the act only I am getting section 1, section 2, helping me to understand the act better. Then comes your chapter is divided into headings, title, etc. Marginal notes, this you might not come across, but in criminal laws, in the act only, in the side there are some footnotes, there are some examples. These are all side notes that are there. For example, they will give you a side note of an illustration that stabbing means, or example of housebreaking, robbery. So the person opening the door and entering in your house, making a false key, breaking the window, all can be considered to be robbery. So the example will be given. That comes in the margin, that is also covered. Illustrations are given and schedules are also given. Schedules also come towards the end of the chapter, which explains a certain part in detail. So a schedule could be that which all industries are coming under the act, that will be mentioned, or what is the fees or what is the stamp duty. It's all given in the schedule. Now understand the meaning of a proviso. Okay, mark this proviso as important and understand. I'll explain it exactly. This you have to write. So a proviso could be for two purposes. How many purposes are there of a proviso? Two. One is to qualify or qualification, or to create a exception. So a proviso. So you remember we write provided that, provided further that. That's a proviso. So it normally comes below the main section and it will start with the words provided that or provided further that. It has two purposes. So either a proviso could be used as a qualification or it could be used as an exception to the original section. So I'll give you an example, you understand immediately. So you can write this in the exam also. So to qualify means, if I say that a person cannot act as a director provided the director has taken a DIN number. Provided that the director has taken a DIN number. So proviso has been given as a qualification that you have to have a DIN number to get it. Okay. Exception means the full rule is applicable provided that the above provision shall not be applicable to a small company. Exception means the rules of your meetings etc. does not apply for small companies. So we have created exception that provided that companies whose turnover or paid up capital is not as per law shall not be required to comply with this rule. So what did I do? A rule I gave, then I added a proviso which creates an exception that for them this rule will not be applicable. Clear till here? So the job of a proviso could be either to create a qualification, that is a requirement, or they could say as an exception. Then we come to external aid. External aid means only when the internal aids are not sufficient, then I'll go to external. I'll read the parliamentary history. I'll go to the reports. I'll go to the other statutes. Now this is called as statutes parimetria. What it is called? Statutes in parimetria. Statutes in parimetria. What it means that statutes having the same subject matter. Statutes having the same subject matter. For example, Companies Act 1956 and Companies Act 2013. These are two different acts, but they have the same. Pari means same and material means matter. Same matter they deal. Again, if I say another thing, GST and excise law, same, statutes in parimetria. If I say Competition Act and MRTP Act, so the previous act which it repealed and came is a statutes parimetria. So obviously I go to the, if I want to understand Company Act 2013, I can even prefer its statutes parimetria, that is 1956 Act. If I want to understand 1956 Act, I'll go to 1913 Act, Companies Act. Okay. Then comes dictionaries can be used and foreign decision, like foreign decisions also we can refer to understand. Now presumption. Now what does the term presumption mean? That you should presume, that you should believe. Default belief. Default you should believe. Tell me, should I presume that the parliament does, while I am interpreting the law, in the back of the mind, can I say all the people in the parliament are politicians, they all are dumb, they must have only made a mistake? You think this is the right approach to read an act while I am interpreting? Or my presumption should be that the parliament knows the law, they don't make mistake, they have every word is important. That all is the presumption. Default belief. That by default I should believe that the words are not used. Words always parliament uses accurately. In criminal acts mens rea is required. Legislature knows the law, legislature knows the parliament, the customs. The legislature does not alter anything unless with express enactment. Legislature does not make a mistake, and normally doctrine of natural justice is always followed. Okay, and now the case law. Okay, now pay attention to the case law. Now again I told you that in this the thing, interpretation of statute, they have this ruling versus Kavi spinning mills. Okay, one case is there for interpretation of statutes. Let's do it. A Kavi, okay, spinning mills. So what did they say? Very simple. The crux of the case is Supreme Court held that when a tax exemption entry clearly and unambiguously mentions yarn, the benefit of exemption cannot be restricted only to cotton yarn or to the handloom industry. Very simple. Let me explain. So interpretation of iOS, we are doing interpretation of statutes. So government, the Supreme Court held that a tax exemption was given for yarn. Yarn is like cotton, etc. So they said that it does not only mean cotton, hank yarn, and it does not only mean handloom industry. Means exemption was given to hank yarn. So hank yarn made from anything is covered, and anyone using hank yarn is allowed, because tax exemption has been given to X. So they have not told which industry, they have not been very specific. So everyone dealing with hank yarn was given exemption. See, what is the fact of the case? That this company claimed exemption for hank yarn. The tax authority argued that it is only for cotton hank yarn and used for handloom sector only. So Supreme Court said that where cotton hank yarn has been given and where it has been said that only handloom industry, how you can say that this benefit is only for handloom industry? You're wrong. So Supreme Court held that hank yarn does not mean cotton. It didn't mention. So cannot be restricted to any raw material, cannot be restricted to any end user. So any end user using hank yarn will be given the benefit. Very simple. With this, we have completed the entire chapter along with the amendments. Thank you. Clear, everyone? So done. We are done beautifully with this entire chapter. Okay, including the past exam question, and every single aspect has been covered which can come in your exam. Depth, covered in depth. Okay, so in the chat box I want you to tell, have you all understood? Perfect in the chat box. Then I will start with my next chapter. Okay, I will start with my next chapter, but till then I want you to write perfect. I want you to like. If you not like the video, be little, big hearted and give it. Okay, just feels good. Doesn't hurt you, doesn't hurt me, but it makes me feel good. Okay, so again, and one request, if you like the lectures, please share it in your study circle group. That is my request to you. Okay, that is one small little thing that you can do for me. Okay, now next chapter in sequence, I told you 3 criminal laws I'll take later. I have to start this also. Okay, so I'll start with, according to me, I'll just start the Limitation Act. So 8 marker chapter, it always comes. Limitation Act, I will start and complete it also, and then I will do you have your RTI Act, and there is also Civil Procedure Code. So we'll try doing those also, but I need energy from you all. I need some responses from you all to keep me going. Okay, I can go entirely, but I expect some amount of support from you. Okay, so in this also, in this Limitation Act, they have given few case laws which I am going to cover also. So mainly covering all those things which are amendments, etc. And you see quite a lot of chapters I am covering. You all just shows that excitement, some kind of love and support. So will encourage me to do better and do more. Okay, and share it among your friend circle also. What am I doing? I'm just going to the particular chapter here. Now in your limitation act also, in your limitation act, they have added quite a lot of case laws. Okay, so all that, I think around 10 case laws have been added. Four case laws have been added. So we'll complete that also. Clear? So we'll take a short break and we'll come back and complete the limitation act also. Good. Everyone, GTG in the chat box. Is it enough if we watch your marathon for JIGL paper? Yes, I'm covering everything. You open your module, you open the past exam question. I'm covering every single thing. All you have to do is take a book, pen and write it down. Write down, note down everything. Everything will be covered. Okay. Now I'm starting and I cover everything. Only thing is you have to keep a tab of it. Or what all I'm saying, doing, you need to pay attention. Now I'll start with limitation act. We'll take a short breather and we will come. Till that, I would request you all to share it among your friends. uh, what's the time now? So we started in 10 minutes. Okay, in 10 minutes we start with this chapter. Hi guys, am I audible to y'all? Just give me 15 minutes and I will cover this entire chapter for you, including the past exam questions. Okay, and your full module as well. Okay, so nothing more beyond this needs to be done, covering everything in depth. So just before I start, I need a confirmation from you all. Am I audible and visible in the chat box quickly? Okay, then I can start. Full chapter will be covered. Including the amendment sheet. Okay, the amendment sheet which is there, which they've given you here. Okay, so this will also be covered. This is your Ajay Dabra versus Pyare Ram. Quickly, I need a confirmation from you all. Okay, Devika, great. Yuvashri, great to have you. Okay, Mr. Viper, great. Chalo, let's start. Also remember, the dream batch is available. It is there in the description of the video. You can get access to all our paid lectures for $299 only. Okay, you can go to our website also, jahangirtutorials.com. It will help you a lot, especially for your examinations. Okay, let's begin. Hi, so now we begin with a chapter which is called as Limitation Act 1963. Now let's understand what is the Limitation Act about. Whenever any SAA is being filed, it should be within time limit prescribed by law. So what is SAA? Any suit, any application or any appeal. So any case you are filing, it should be filed within the time limit. Sir, where is the time limit given? The time limit is given in your Limitation Act 1963. Okay. So for every case, you cannot just go after 100 years if anything wrong has happened. Now remember one legal word I'll teach you, that if a wrong has happened today, that wrong I'm going to call it as cause of action. So if a cause of action means the reason for filing the case happened today, so today your contract was breached, or today there was a murder, or today there was a check bounce case, so today will be the cause of action. So from here, within a certain timeline, you have to reach the court. Only then the court will give you remedy, otherwise the court will say sorry, time limit is over. So if you see this R glass, can you see this glass? It shows that the moment something cause of action arose, the R glass starts. That means if this time is over, then court will not entertain you, will not give you relief. This is the entire basic of the chapter. So the time limit is prescribed by law. Whenever a suit, application or appeal, SAA is being filed before the court, it should be filed within the time limit. Now the question is why I should file within time limit. Wrong has happened, right? So court should anytime give me relief. So law says, listen, with time, evidence fades. With passage of time, evidence fades. If today I will come and say 30 years before some wrong has happened with me, court will say, how will go in past and recover evidence? So with time, evidence fades. Your case becomes a stale case. Or, stale. It is old case. Okay, so remember, law extinguishes stale demands, outdated demands. It wants you to be diligent and active and not indolent or lazy. So the law helps the vigilant who are active and not the indolent who are sleeping. This is the law. Now we go into the sections. The first thing is called as section 3, the bar of limitation. Now what is this limitation? What does it do? It creates a bar. What is a bar? A bar is a block, a halt, a restriction. Okay, restriction that no court in India can take up a matter which has crossed the time limit. So once the time limit is over, the courts, Indian courts are barred, are stopped, are restricted, are disallowed from taking up the matter. The government has said, already parliament has said, already so many cases are there. Now after time limit one, you don't take. So that is given in section number 3. That if whenever any SAA is filed, it is a duty of the court not to proceed with the suit. Even if the party says, okay, I want to take up, court will say that don't hide. Even if the parties don't raise an objection, parties are okay with it, court is only barred from taking up the matter. The court can still not take the case if it is barred by limitation, if it is stopped by limitation act. Finish. Now there is a very classic line given that the court only bars the remedy. It does not extinguish the right. They can ask you a short note. Write a note that the court bars the remedy but does not bar the right, does not kill your right, does not extinguish your right. So first you will write as per section 3 that section 3 courts are barred from taking up matters which have exceeded their time limit. Now you will write this line. Understand what I am saying. First understand the case. That imagine this one person is there and this is the other person. He is the lender, this guy is the borrower. Okay, let's say the time limit is prescribed by law is given as 3 years. Now the borrower did a default. He didn't pay the money. So the lender should have gone to the court. He should go up the court for relief. Right? Time limit is how much given by law? 3 years. This guy goes to the court after 4 years. Tell me in the chat box, can the court take up the matter? Yes or no? If they cannot take up, under which section are they? Is the court barred? Under which section is the court barred from taking up the matter? Time limit is 3 years and the application is filed in 4 years. After 4 years. Quickly. Okay. So now, very good. So under section 3, bar on limitation. So the bar is a restriction created on the court only to take up the matter. So now one line I am trying to explain is that the court bars the relief but does not extinguish right. Now understand I am explaining this line. So what did the court do? Did the court give the relief? Court will bar the relief. Court said get out of here. But out of court this lender went, he spoke to the borrower and the borrower said okay fine, I will repay it to you now, let's pay this amount, and they closed it. So is this transaction allowed where out of court they have agreed? So court said yeah, that's absolutely fine, we did not kill your right, we did not extinguish your right, you have a right. You have a right to recover. You recover it and close it, but we will not give you remedy. So what does this line mean? That the court does not give the remedy. The court is not killing your right. If you want, you can get it through other means. Out of court settlements you can do. So the intention of the court is not to extinguish your right. We don't want to kill your right. You have a right. You have come late, so we are not giving you remedy. You get your remedy from your own self. Find out how you can recover. So the remedy court will not give, but you can always claim it through other means. Okay, that is what has been given. Now section 4. Is section 3 clear? It is important section, you should know, including what I have explained. Very good. Now criminal cases, does it have time restriction? Answer is absolute yes. Even criminal cases have time limits. So for example, check bounce is a criminal case. It will have 1 year, you have to go to court. Defamation, it has a time limit. Okay, so all criminal, even little grievous offenses also little bit has a longer time limit. But extremely severe matters might not have a time limit. Court can still take up murder, extortion. You can come later also. But for small things like this guy beat me up, he broke my bone 3 years back. So law has put a time limit. So criminal matters also have a time limit. If the court is closed on the last day of limitation, I told you 3 years is the limitation period, last day court is closed. So fine, can be filed on the next day. So one day When the court reopens, you will get. So 1 day extra they are giving you when the court reopens. Now normally, initially I told you that the court should not give you take up the matter beyond the time. But if you have a genuine reason, if there is a doctrine of sufficient cause, if there is a reasonable justification why you didn't come, maybe you were caught up, maybe you were ill, maybe you were anything, with the court deems fit, they can give extension of time. So court has been given that for sufficient causes, they can condone the delay, they can pardon the delay, they can allow the delay. That is section number 5. Section 3 is bar, section 4 is the next day, because if it last day is a Sunday, then you will take the next day. Okay, limitation period. Then section number 5 is extension of time can be given. This is called as doctrine of sufficient cause. If the courts feel that any appeal or application could not be done due to genuine sufficient reasons, then the court can at its discretion, at its option, you cannot order the court to give you, they can at its discretion give you. Okay, they've given you on which all matters court can extend. Maybe you had approached a wrong court, you had got a wrong counsel advice, wrong advice, maybe you were in jail when all this wrong happened with you. Okay, illness was there of father, all this is there, but it is very, very individualistic test. For every matter we will see that whether it was a genuine delay or no. Okay, now comes to section number 6. What does section 6 talk about? Disability, that legal disability. Section number 6 talks about legal disability, that if any person is in a legal disability, okay, before the date of default, then obviously he cannot file a case because he was in legal disability. Then the period of limitation will not start from the date of default, but it will start from the date of cessation of disability. Let's understand this nicely. That let's say someone was trespassed on your property. So there was a trespass on your property. Okay, so this was the house. Someone came and was chilling in your house. So normally, let's say he did it on Sunday. So from here we will start your time limit, and let's say time limit under law, time limit is given as 1 year. So 1 year will start from the date of default or from the cause of action arose. Now this was the cause of action arose on this date. From here we will start your 1 year time limit, that hourglass will start. But if before the cause of action you were under a legal disability means law believes that you were under in eyes of law you were under disability. Let's take a genuine thing, that you were unwell. Not unwell means you were in coma, or a person was extremely paralyzed. So obviously on the date of cause of action he was under a legal disability, so he cannot file a case. So his time limit is not fair to start the time. You start and end and he is in coma only. So his time limit will start when the legal disability ceases. So when you cease to have legal disability, means when that legal disability stopped, now you can file a case. So now we will start the time. So if this is the default, on the date of default only you are under legal disability, so we will not start your time. We will start your time, this thing like a stopwatch, we will start your time only when you come out of the legal disability. I'll give you another example of disability seen in the eyes of law. If you were a minor, okay, so now obviously minor is not capable of forming a judgment and your uncle took away your property. So we will not start your, and there is nobody else except for you. So then you cannot file a case because you were a minor and nobody else was there. So when you turned majority age, majority, now we will start your time. Why? Now you cease to the legal disability ceases. Concept clear? Right? Now let's see. Now we'll read it again. Okay. If a person is under a legal disability and the disability happens when before the default, on the date of default, from way before you are under the legal disability, then the period of limitation will not start your timer. Okay, from the date of default. Will not start from the date of default. Why? Because on the date of default you are under legal disability. So we will start it from the date you ceased. Cease means the legal disability ended. Finish. If there are two parties, then obviously when if there are more than one disabilities, then where all the disabilities have ceased. For example, he was a minor and paralyzed. So he became normal, but he is still minor. So when you cease to have all the disabilities, then you can do. Now the thing is, if the disability continues up till death, person died only. So then, moment on your death comes, the time limit will start from the minor, from his legal representative, when his nominee comes in. So moment a nominee has been appointed, that time we will start the time limit. So pretty simple, okay. So and it's logical also. So if you are under legal disability, how will you file a case? We will only start when the legal disability will cease to exist. Disability of several persons. So above we saw in section 6 is multiple disabilities you have. So all the disabilities will end. Or one person only. Huh? Now we are seeing that there are many people. Let's see. There were two brothers. Okay. Same example. Okay. This is the uncle. He took away your house. Uncle took away your house. And there were two children. You and your brother. Okay. He was your elder brother. He is 17 years old. And you are the younger brother. You are 16 years old. And both of you all should have ideally got this house. Now what happens is, this guy turned 18. So you tell me, can I say that one is out of legal disability? So should we start the time, yes or no? Should we start the stopwatch? That listen, one of them is out. So obviously he can file a case on the uncle. So for both of you all, we'll increase the timeline. What do you think? Or we should keep it individually, or we should wait for the younger one also to come? What do you think? So law says that listen, we are not here to give exact justice. We are simply saying that one guy is there now, he's out. Finish, we'll start the time limit for all. If this guy could have represented both the parties, joined up, he could have filed. So before both of you all, it will be started. Law is not going to wait too much. It wastes time. Court also wants to end matters. They don't want to take up matters. So where if more than one plaintiff and all the plaintiffs are under legal disability, so we can't start your time. More than one person is under legal disability. So time limit for all the plaintiffs will start when you have cessation of disability of any one of the plaintiff. So if any one also is fine, then the time limit will start for all. So all of them, if they come out, then they can beat up the guy who didn't file the case first. Okay. Now comes continuous running of time. Very, very, very important. Okay. Continuous running of time. Very simple. That, and there is a line. Okay. There is a line that once the time starts, no subsequent or later disability or inability will stop the suit. Once the time starts, then there is no chance that it will end. Let's see. So in all the cases above, section 6 and 7, what happened is, if this was the default, wrong happened. On the date of default, in section 6 and 7 when we are done, on the date of default, the plaintiff, the person who had to supposed to file the case, plaintiff, was in disability. Yes or no? He was under disability. That is why we couldn't start the time, because on the date of default he was dead or he was in coma. So he cannot file a case. So we'll wait for him to become fine. Now take this scenario that he was fine here. He was absolutely fine. Now we are talking of section number 9. Okay. That he was absolutely fine on the date of default. After 3 months he went into legal disability. So here the time had started. Time started because you were in a position to file a case, and subsequently you went into legal disability. So should the time stop, pause? They say no. Once the time limit starts, then it will wait for no one. Then it will continue completely. So once the period of limitation starts, it goes on. It does not halt. This is called as continuous running of time. If on the date of default you are in disability, then we are ready to wait. But on the date of default, if you're fine, okay, then for how much ever time you could have filed the case. Later, everyone in their lifetime they will fall sick. There something will be there, so we can't keep waiting. So once we start, then it will keep going. Okay. So continuous running of time is what? Okay. That thus the time runs when the cause of action, the person's right has been violated and he's in a position to file. So moment we start the time, when he's in a position to file, we will start your time and subsequently then we don't stop it. Then no chance that 1 year will keep going on. Okay. Once the period of limitation starts, it will not end. This is what the main rule is. Now, understand section number 12. Section number 12 is talking about exclusion of time in legal proceedings. Very, very, very simple. Okay. Very, very simple provision. What does it say? Pay attention. That in computing the period of limitation, while computing the limitation period, the date when the cause of action arose shall be excluded. Means the date when the cause of action arose, that day will be excluded. For example, on 1st October, there was a breach of contract. So will we start your time from 1st or we'll start your time from 2nd October? You tell me, we'll start your time from the date when the cause of action arose, or we will not count at 1st October and we will start it from 2nd October. So we will start it on 2nd October. Clear? Second, now all these points are pretty similar, that in computing the period of appeal, application, etc. for leave, the day on which the judgment complained of was pronounced and the time for requisiting of the copy sentence appeal shall be excluded. Means understand what they are telling you. This very one day they are counting now. So this is there. The day of the default is not to be counted. Now they are saying when you are going in appeal, okay, or filing anything, so we have to get the copy of the order from the lower court. So the time requisite for obtaining the order of the decree, the day on which the judgment accompanied was pronounced, and the time for obtaining the copy shall be excluded. You tell me, isn't it fair that judgment I want to go in appeal? What is this provision for? Is specifically for appeal. Okay. So I am waiting for the judgment copy from the lower court. So the lower court has to, I made an application, they have to give me the order copy. So the order copy they gave me after 1 month. So how you can start my time? You can only start my time after I receive the order copy, because delay is from court end, not my end. I filed the application. I filed let's take an example. Matter is in NCLT. I want to go from NCLT, I want to go in appeal to NCLAT. Okay. I want to go in appeal to NCLAT. So what happens is, NCLT, I gave an application, NCLT took time to give order copy. Without order copy, I can't go in appeal. So is it my fault that the lower court is taking time? No. So they say that this time where the court is giving a delay for giving you the copy, order copy, will be excluded. Concept clear? So this is what has been given. Same for order, everything. Appeal. Now all these points are the same. If you're getting a arbitration award, then the time till you get an arbitration award in hand, that will be excluded. Now, section number 16, effect of death or before accrual of the right to sue. This we've already decided that if a person dies and is legal where the legal representative is appointed, then we will start his time. So in case in case of death of a person before the right to file a case, the period of limitation shall be computed from the time when there is a legal representative deceased capable of instituting a case. So if there is a death, then we will start your time when the legal representative is appointed and he is capable of filing the suit. Simple logic. Then comes two important things, section number 18. Okay, what are we seeing? Section number 18, effect of acknowledgement of period of limitation and effect of part payment. Both of them have the same effect. If section 18 and 19 are the same, pay attention. What are we doing? We're doing section 18 and section 19. What is section 18? Your effect of acknowledgement of debt, and the 19 is effect of part payment. Okay, your effect of part payment. Now see, what happens is, in case of you've taken a borrower is there, someone is borrower lender case. Okay, there is a debt involved, there is a loan involved, So then, if imagine the borrower has given to me in writing that I will repay you the money. So can I say that a fresh evidence is created? Fresh evidence comes in. So the date of acknowledgement, he has to give me in writing that he owes the debt and he will repay it to me. So because of that, what will happen? A fresh period of limitation will start. Fresh period of limitation starts. Clear? Effect of part payment. Now what is effect of part payment? Similar thing will happen. That moment the borrower has paid some money, the borrower is there, he's given a part payment. So now again, why will I go a case? He's trying to repay it. So then the period of limitation gets extended. So a fresh period of limitation starts. What does it mean? That if, so here also both of them has the effect of a new evidence and new acknowledgement. So what happens is, fresh period of limitation will start. Means if 3 years were there and he made a part payment or acknowledgement, again 3 years I'll get. So let's say this was a period of limitation, this guy approved here, so fresh period of limitation will start. Then again he gave some payment here, so again a fresh period of limitation will start. So with this, what happens? Law says, okay, fine, let him go. There is something ongoing, some activity coming, he's acknowledging, he's making a payment. So we will continue. We will say that, okay, fine, default date is extended because the person is trying to repay the loan. So the lender also doesn't get tense. He says, okay, I have 3 years now. So burden of court is also less, and some kind of adjustment and arrangement is also happening. Court can see. So acknowledgement. So it should be an admission. He should give in writing. Okay, a copy must be given. It should be before the period of this, and it should be signed by the party, and it should be before the limitation period. So before the limitation period, if I write that I'll pay my loan to you, so fresh period of limitation will start. If all the above conditions are fulfilled, then a fresh period of limitation shall be computed from the date when it was acknowledged or signed. Effect of part payment also, moment you made a part payment, a fresh period of limitation will be available when the part payment was made. Now we come to acquisition of ownership by possession. Section number 25. What it says that for 20 years and for government property 30 years. If on any property you are living for 20 years, like the Adivasis, and they are there, okay, for 20 years they are there, from so many times when civilization was there, there is no property that time. Now first who came and 20 years uninterrupted, peaceful possession you are having, then you become the owner only by possession. So you become a possession and you get a right to access, window, etc. with peaceful enjoyment without interruption. Then you will be shall become absolute and permanent, cannot be taken away by law. So once you have a right to access anything which is enjoyed peacefully for 20 years, means what? There is no owner. Or if government is there, the owner is dead, government is there, so then 20 years normally, but if it is a government owned property, then 30 years. So that is why you see on the slum rehabilitation, what is happening in slums, they are there for 20 years on the road in one slum. Now law is recognizing them, they are giving them alternate accommodation, because as per section number 25 they can't be removed now. 20 years or 30 years they are there for many years on a land, so that becomes the owner. Now one of the most important thing, limitation period and writs. So the first question is, I want you all to put in the chat box, does writs or are writs subject to limitation period? Are writs subject to limitation period? I want a yes, no from you in the chat box. Okay, I'm not going to tell you anything. Is writs, filing of writs, fundamental rights when it is violated, subject to limitation period? Yes, no, quickly in the chat box. So here we will be seeing this. Okay, you can read and tell me, then we will see. Okay, subject of limitation is dealt under, so is under the Constitution of India, limitation period. So when I see the Constitution of India, entry number 13 list 4 is talking about limitation act, provisions of limitation. What does it say? That the legislature may, without violating fundamental rights, enact laws, okay, and they can shorten the time, etc. as reasonable it is allowed. The state cannot place a hindrance by prescribing a limitation period in a way that the aggrieved person seeking to approach the Supreme Court under this. So the first line is, the Limitation Act was passed under your list 3, entry number 13. That the legislature can, without violating fundamental rights, enact statutes. Second, they say that the state, the government cannot place a hindrance or obstacle by prescribing a limitation period to approach Supreme Court under Article 32. So they have said that you cannot create a limitation period for writs. Third, to put curbs by way of enforcement of fundamental rights through legislative action might be questioned under Article 13(2) as unconstitutional. If you made any law which is making that writs cannot be filed within a certain time, then it is violating 13(2). 13 sub 2 says that any law made after the Constitution is made, which is against the Constitution, is unconstitutional. So it will be treated as unconstitutional law. And Tilok Chand Moti versus Munshi. The limitation period does not apply in Article 226 and 32. So the main line is, the limitation period does not apply under Article 32 and 226 of the Constitution. Is this clear, everyone? So if you can you answer this now? Are writs subject to limitation period? Answer is a big no. So they have said that you cannot do anything where the fundamental rights will be violated. Even list 3, entry number 13, it is said that don't affect the fundamental rights. Now, in the case of state of MP versus Bhai La Bhai, courts act on the analogy of statutory refuse relief if the delay is more than the statutory period of limitation. Now understand one thing, that even if the particular law cannot be made for writ filing, but courts always have a right to give relief on them. So they can hear the matter and they can refuse the relief if normally it is beyond the statutory provisions of limitation period. Means if a matter for which 3 years is prescribed, so now you can't go to court, so you will say, okay fine, let me file a writ. So now you are finding an alternative loophole in law. What you are saying that if time limit is given and time limit is over, so I'll file a writ petition and I will go in High Court, because no law can be made putting a limitation period on writ filing. So then they said that, listen, we are not stupid. If we come to know that your statutory time is over, the court can refuse. They are not taking up your matter. They might hear you and they can refuse giving the remedy. So that is what they are saying, that if it is a lot of delay, then court can refuse also, because the giving relief is completely discretionary of the court. Now they have told, now you don't have to learn all of this, but period of limitation, how it looks, a schedule has been given. So if it is normally bills of exchange, factors, all this, you don't have 3 years has been given like this. Principal agent. For property matters, obviously you'll have more. Okay, for check bounce, etc. So the list has been given. Classification, if we go to see overall classification, period of 30 years obviously will be for property matters. So let's see that the maximum period is under limitation period is 30 years. It is given for mortgagers, okay, when they are trying for redemption or recovery of possession of immovable property, mortgagee for foreclosure, and suits by on behalf of the central government. Let's understand. So 30 years has been given for what? 30 years time limit, which is maximum time. For suits by mortgagors for recovery of possession of immovable property. So when the mortgagor is a borrower wants to recover his immovable property by paying the loan amount, he can file a case. He has 30 years of time that, listen, I have paid the full money, please give me my property back. So the suit by the borrower to recover his immovable property. Then comes suits by mortgagee for foreclosure. So the mortgagee is the lender. So if you have not paid the loan, okay, so then the bank also has 30 years time to go and file a case in court. Foreclosure means to close the matter by selling the property. And if it is with respect to central government, then, or against any government, then 30 years time limit is given. 12 years is given for immovable, other than all this, immovable property, trust, endowments. 3 years is given for relating to accounts, contracts, declaratory suits. So this you can study rather than the full table. The period of 1 to 3 years has been prescribed for torts, other miscellaneous matters. And period in delays between 90 to 10 days. The minimum period of limitation is 10 days, is prescribed for a leave to appear. Some least means in summary matters, they tell you that time limit is within 10 days you have to come to court. It's a small matter. So that is the least time limit which is given. Okay. And then when we come, we are done only the case law. So if you see this Ajay Dabra versus Pyare Ram and Vailamai Murali, these two, and this is the case. Purni Devi is the third, and fourth is Subha Reddy. Okay, Subha Reddy. So let's do all the four. So first one, Ajay Dabra versus Pyare Ram. The Supreme Court held that financial inability to pay the court fees. The Supreme Court held that the financial inability to pay the court fees is not a sufficient ground for condoning the delay under Section 5. Section 5 was that excess time. He said, why you didn't file the case? So I didn't have money only, I was really poor. Then that's not a good reason, is what the case has said. Second, in Murali case, the court repeated that for suit seeking specific performance, the limitation period is 3 years. Specific performance is 3 years. In Purni Devi versus Babu Ram, the court held that the time spent by a party in bona fide litigation before a wrong forum must be excluded. So, guy was there, he made a bona fide litigation. Genuinely, he filed before a wrong court. So, that time is always excluded. So if I went to a wrong jurisdiction court and I wasted 3 months, that much time can be excluded. Then comes Subba Reddy. The Supreme Court emphasized that the merits of the case are irrelevant. The Supreme Court emphasized that merits of a case are irrelevant in deciding the application under Section 5, and the rights not existed for long must cease under the law of limitation. So they said that it doesn't matter, why will we go into merits of case? If it is time barred, if a matter is time barred, you've come after the time limit, then we will not go into the merits in the details of the case at all, is what has been given in Subba Reddy. Okay, with this we have completed the entire 8 marker chapter of Limitation Act, including all the past exam questions and the latest case laws. Thank you. Clear everyone? I want you all in the chat box. Have you all understood this perfectly? Yes or no? Yes or no? Have you all understood this perfectly crystal clear in the chat box? I have covered everything, okay? Everything, okay? So then we can start with the next chapter. In the chat box waiting for you. Everything is crystal clear. Great. Yuvashri, thanks for responding. What about others? Okay. Pakka sir, Darshini, nice to hear this from you. Okay. Now, what about others? Now, we are going through knocking off chapters. Okay, we are knocking off chapters from here. Kautam, well, Ram, great. So, can we move ahead to the next chapter and knock that off also? So, I'm thinking I'll take up your right to RTI Act, Right to Information Act. Okay, so we'll complete the RTI Act also and complete it. So we are completing the RTI Act. Quickly, we'll complete it in a short time. Okay, so be with me. So at least this 5 to 7 mark chapter also is in your pocket, and then we'll start with another good topic. Really great to have all of you all. Okay, so now we'll start right to information. We'll complete it in like 20 minutes. We'll just take a break of 10 minutes break, and then we'll complete the chapter. So don't go anywhere. Just one request, please share this video link. I take these lectures in English so that especially students from South India can watch and learn as well. So if you have any of your friends, do let me know in the chat box you're from which state, which city you belong to, which city. I'd love to hear from that. You all are from which city? Okay. Let me know. So it just encourages me, and then I'll complete the entire chapter. Okay, so we take a 10-minute break and we come back. I'll be reading it. You all can type in the chat box. Okay. So hi guys, am I audible and visible to y'all? I need y'all to put in the chat box a yes or no quickly. Okay. Great. Okay. So Darshini, Abioli, you all are from Chennai, and even I think Subeda and Yuvashri. Great. So you all are from Tamil Nadu. Great. Okay. So now I just need you all to tell in the chat box whether I'm audible and visible, so I can go ahead and complete the balance part of the chapters also. Okay, Yuvashri, great. So thank you so much for being there till the very end. The more you all are excited, the more excitement and energy I have. Madras, okay. Shri Ram, nice. GTG in the chat box and I start. GTG in the chat box and we start. Quickly, GTG in the chat box and we start. We'll complete the entire chapter. Waiting for your response. Okay, great. So we will be beginning with lesson number lesson RTI. Great. Let's begin. Hi. So we start with the act called as RTI Act, a very simple chapter. What does RTI Act mean? It is an act which gives information to the people, to the citizens of India with respect to anything that is there with the government record. So if I want to know that what is any building, any documents, details, data with the government, we have a right to get access to it. Now, why are we allowed to get access? Because it is as a part of democracy. As a part of democracy, citizens can participate in making the government responsible, and we can question the government only if we get information. How did they perform? Where did they spend the money, etc. Okay, who has been given the project, and then we can do our investigative. All those things. Investigative journalism can be done. Citizens can do investigation, question the government and put them accountable. So let's start. The Right to Information Act. Now what is the Right to Information Act? It gives you a right to the citizen. It's a right to the citizens to get access to information. Right to information. So we get a right to information, okay, with respect to information that a public authority has, a government has control of public authority. So private organization, obviously you cannot file an RTI. Now RTI is always filed with government bodies, okay, only with records held with government. It came into effect on 12th October 2005. Now there was a very classic example of right to know, that only when citizens will get information, only then they will be able to question the government. So it came that Article 19(1)(a) is hit, the right of speech is affected if information is not given. If government information is not given, all the data of the information that you need is not given, obviously you will not be able to speak. In return, if I come to know that this is the government record, this is how much money is there, this is where they spent, then I can question the government. If today you come to know that the president has spent so much in travel of the world, then you will ask that if so much money is there, then what benefit did we get? So all those questions citizens can ask. So RP Limited versus Indian Express, the Supreme Court held that into Article 21, the right to know. Right to life includes the right to know. So it's my right. Okay, it is a part of participatory democracy. So we can participate in democracy only we get information. So Article 21 confers that a right to life includes a right to receive information. In Raj Narayan versus State of UP, it said that people cannot express or speak until they know. Therefore, it is connected speaking. Article 19(1)(a). The object of the act is to give access to the information with the government, create transparency, etc. Now when you go to see, we get, what was it, that the act is a right given to citizens to get information from the public authority. Now what does a public authority mean? Public authority means public authority, government authority. Either it is constituted by the parliament under the constitution, state government, or any other act has formed this authority in which government has control. So for example, police station will come here. I can get the information about any FIR, about any crime records I can get. Second, we can get a government hospitals. I can get details about government hospitals. With respect to any government funded schools, we can get information, anything we want. And the information can be given in any CD, floppy, etc. So you write, as a citizen, you will write an application to, I'll tell you to whom also. It's a public information officer who you write to. Every government department like RBI, SEBI will have a PIO, public information officer, who will extract the information and send to us. So if you are here, okay, you are a citizen and this is a government body, then in the government body there will be a PIO, a public information officer. So application is written to him, RTI application is written to the PIO, public information officer, that give me information about this land records, about this SEBI, and then the PIO will respond to you. Okay, records means any records whichever the government has, could be any document, any kind of film, any kind of images, etc. Okay, right to information. Now how you define RTI? So it means a right to information held with public authority and includes the right to taking notes, inspecting their work, taking samples, taking it in CD tapes, etc. Okay, now we come to section number 4. Very important. That, do I write to the public authority only? Answer is no. I see the public authority is there, okay, but public authority might not give you the information, so therefore we appoint a PIO in every public authority. So if imagine a bank is there, government bank, etc. So a bank will have a PIO. I will write to the PIO and I tell that you please get this information from the public authority. So what is the duty of the public authority? Is to give information, is to appoint the officers, etc. So let's see. Every public authority, they first have to have information to give. They must maintain all the records or whatever information in any form, and they should give the information within reasonable time. Okay, this is when the act was passed, so not important. Then section number 5, designation of the PIO. That, what did I tell you? You have to appoint a public information officer to whom you write application, they give you. So every public authority has to have a PIO at all administrative level, and at subdivisional level they will have an assistant PIO, a lower guy above them. Okay. Then always whenever you are filing an RTI application, it is filed under section 6 and 7. So section 6 and 7 is a request for obtaining information. Now if I give an application for RTI, then give me information about this university funding, etc. Where did they get, where did they spend, how much did they get. So that university will have to respond to me, but within how much time? So 30 days, 45 days, 48 hours, 35 days, all these days are there, and 40 minutes. So all the timelines I'll tell you. So you have to know which is the right timeline. Okay. So normal applications has to be responded within 30 days. So moment you make an application to the PIO, he will respond, he will give you the information within 30 days mandatory. If you file it to the assistant PIO, then 35 days. These two are done. Okay. If within 30 days it is not responded, means it is deemed refusal. Now, if imagine some urgent matter is there, I'll give you an example. If there is a person who is unwell, medical case, is there. Okay, there was a husband has beaten the wife, and now wife is almost on the deathbed. So what happens, and then this wife had gone there was a medical record with the government hospital. Now we need, because the person is very critical, we need the information immediately because life is involved and liberty is involved, so we need a urgent case. So in 48 hours it will be given. So moment an application comes that this is with respect to someone's life is at stake, some liberty is at stake, this person is in custody, we need this information. So immediately I want that medical record or whatever information is held with the public authority. Okay, and last is, this is 48 hours, and last one is 40 days. So now if you see, the maximum time here is 40 days. So whenever you're asking an information with respect where a third party interest is involved, for example, I am filing an application with Bandra court to know that what is or with a family court to know what is happening within Ritik and Suzanne. So they say that, listen, Ritik and Suzanne are two different people. You are asking information which can affect a third party's interest. You have nowhere involved in it, you want to ask. Okay. So for example, if you know that, if I want to know that this politician has a correct degree or no. So I write an application that I want to know that whether this politician's degree is fake or it is real. I write to that university, tell me what was his number, give me all his mark sheets. I need to know. So now what is happening is you are asking information about the third party. So the PIO will wonder, I'm wondering whether I can give or no. So 40 days time. Clear till here? Now comes duties of PIO. Exactly, you will reverse the pointers which has been given here. The duty of the PIO is to respond within 30, 48, 35 days or 48 hours as the case may be. And if you file it with a wrong PIO, if information is given to the wrong PIO, then it is his job to transfer it to the right PIO within 5 days. Okay. Let's see. Now partial access can also be given. Okay. If you have asked for some information which can be given, which cannot be given, then wherever it can be given will be given, and what cannot be given will be rejected with reasons. Okay. Honorable Court in Central Board of Secondary Education versus Aditya Banopadhyay, it was held that indiscriminate and impractical demands, any kind of demand you ask under RTI, okay, would be counterproductive, will not be helpful, instead it will be not helpful. So this should be rejected. Simple. Now comes, all information can be given except if it is falling under section number 8. Very important, very important. Section number 8. Section 8 says information which cannot be given. I want to ask about government secrets, etc. So they say no, this information cannot be disclosed. So whenever I am filing an application also, I will write that this information that I am asking, which I am seeking, which I am requiring, is not falling under section 8. So certain categories which are exempted from disclosure under the Act. So whichever affects sovereignty, integrity of India, which is forbidden by any court, which is breaching the parliament, rules of parliament privilege, trade secrets if I am asking, any information received in a confidence from a foreign government, endangers the life of any person, it is coming in between an investigation, I want to know who is the witness. Cabinet papers, again, which is what the ministers speak within the parliament. Personal information that I am trying to ask, which is an invasion of privacy, such information will be rejected. So from your 9 points, how many can you remember? So trade secrets, sovereignty, integrity, forbidden by court, parliament, 2 points are there. From foreign government, which information I have got, that cannot be disclosed, etc. Cabinet papers, etc. Now, can partial information be disclosed? So only that part which does not contain exempt from disclosure information, that can be shared. So this is exempt from disclosure. What is the heading? So which is not exempt, that only can be disclosed. Then obviously government agencies and your secret agencies are like your CBI records, etc. will not be given. Now we come to commissions. What happened is, understand that this PIO officers, etc. Above the PIO, who will be there? See, understand that what if the PIO only became corrupt? He's not giving information, and I want to go in appeal. So government has made information commissions. So they overlook. What is the job of information commission? They overlook the PIO. They will see that PIO should be appointed. They will penalize the PIO. So for central government also makes, and even the state governments has some information commissions who will hear appeals from PIOs. Let's see. Okay. So your central information commission obviously formed by the central government appointed by the president of India. So obviously this state one will be by whom? State one will be constituted by state government and it will be appointed by the governor. Exactly, roles will be the same. Okay, they will be persons with eminent knowledge, experience in law, etc. They shall not be a member of parliament, should not be not holding any political designation. They'll be appointed for a term of 5 years. Okay, so this is given. Now what do these information commissions do? So section 18, powers of the information commission. So the central and state information commissions have a duty to receive complaints from any person. Okay, so they will receive any kind of complaints from any person with respect to PIO not appointed. He refused the PIO, refused the information, did not give a response, charged extremely high fees, gave false information. Okay, so in this penal provisions will be done. Appellate authorities, as I told you, any person aggrieved by the PIO will file an appeal. First appeal is to the concerned PIO, from assistant to your senior PIO, and then second appeal obviously is with the commission. Okay, within 90 days when the decision was given. So assistant to PIO, so you have your assistant PIO, to PIO, and then to information commission, 30 days, and this is 90 days. Okay, now section 20 also they've asked you, which is your penalties. So section 20 they've said that the act imposes penalty on the PIO for failing to provide information. Every PIO will be liable for fine up till this amount, maximum 25,000. So we are saying what penalty will be there on the PIO. So 250 rupees per day if he is delaying information, up to maximum of 25,000 for not accepting the application, delaying, denying, giving incomplete information, destroying the information, or obstructing the information in any manner. Okay, now we see the case law that has been done, which has been given now. The Central Information Commission versus DDA. The Supreme Court held that CIC possesses the power under section 12 to frame rules, regulation, forms and necessary measures to manage the direct affairs of the commission for effective functioning. Obviously, the Central Information Commission possesses the power to frame all the measures to manage the affairs of the commission for effective functioning. The Supreme Court held that the principle of that the objective of the RTI is to promote transparency, accountability. To fulfill this goal, the efficient functioning of CCI is essential. The court held that grants the CIC the implied powers to decide the bench, allocate the work, do the administrative work. This ensures timely disposal of cases and strengthens the citizens' right to information. Okay. So what did this case say? That CIC has powers to appoint from the internal laws, etc. obviously, to make this act more meaningful. With this, we've covered the entire chapter on RTI. Thank you. Clear, everyone? Is this clear, crystal clear in the chat box? Yes or no? Vaishali, great. Okay, great. All of you all are writing GTG. Excellent. Are you all ready to do another chapter? Yes or no? Clear. Darshini, great. Okay. Yuvashiri, great. Excellent. Thank you so much for your responses. Now I'm going to take up one more chapter, which is a big chapter, which is called as Code of Civil Procedure. Everyone, Rohan, great. We can. Okay. Everyone's with me. We will complete one more chapter, which is called as Code of Civil Procedure, CPC. Are you all ready to do it? Yes or no in the chat box. Everyone. Yes, we can. Catrioli, great. Okay. So we'll start and complete this chapter. Okay. So we'll take a 10 minutes break and then we'll come back. Okay. So 10 minutes and we'll be back to complete the chapter. Okay. Great. So 10 minutes and we are back. Hi guys, am I audible and visible to you all? And is my screen also audible and visible? Or screen won't be visible, audible it will be visible. Okay, quickly in the chat box. So we can quickly complete this entire, this chapter is for 8 marks, okay? 8 to 10 marks easily, 10 marks easily, okay? So in the chat box, am I audible and visible? Waiting for you all to respond in the chat box. Quickly, waiting for you all to respond. Okay, Yuvashri, great. What about others? Am I audible, visible? Can we begin? Yes. So just today's lecture, if you see, we've covered a lot of portion, okay? So easily multiple chapters have been covered. So if you all just support me a little bit more, I want to complete one more beautiful chapter, okay? Velram, great. Shakti, great. Raghu, okay? This one request also, please, okay, we taken so much effort, so much goes in speaking for so many hours. If you can just share it in your groups, study groups, I'm sure you must be in some study group. Just the video link, please share it in your group so that it helps, you know, this effort that we put. I would want more and more people to get benefit out of. You know, you never know if someone will just clear the exam because of this. Okay, so let's start. Let's begin. And do like the video if you've not yet liked. Okay, I'm looking at the likes. I know it doesn't matter, but for me it does. Okay, I'm just looking that people should appreciate and recognize the efforts put in. Let's begin. Hi. So we start with the chapter called as Code of Civil Procedure 1908. Now let's understand, matters could be either civil matters or criminal matters. Now for criminal matters we have the BNSS Act, which was earlier the CRPC. However, for the civil matters we have the Code of Civil Procedure. What does it talk about? It covers the procedure to be followed in civil matters. So how the petition will be filed, how the party will be summoned, how the hearing will be done, how the cross examination will be done, how appeals will be done. So all those aspects are covered in your, all procedural things is covered on your CPC 1908. Now in that we have to understand few terms. One, and very important, asked in the exam also, what is difference between judgment, decree, order? Now understand, the word judgment we all know is the decision of the judge, okay, the statement given by the judge. But two lines I want you to tell, that it covers the reasons for the judgment also. So it is not just a it's not a judgment, is not the final verdict. It is the final verdict along with the reasons. So this is what people don't know, along with the reasons. And one more line, it is based on the decree or order. So now the judgment is always based on decree. So we'll see what does the word decree mean. So decree is covered under your section 2 subsection 2. Let's see. So this was judgment was under section 2 subsection 9. Statement given by the judge on the grounds of decree and order and along with the reasons. Let's see what is a decree. Now in civil matters, let's say if simple, okay, CPC 1908, we're talking of a civil case. So let's say a property dispute is there, okay, a property dispute is there. Let's say this girl is there, okay, she is saying that this other girl has done something wrong to her property. She is not getting out of my property. So she put allegation. She put a allegation on the other side. So she becomes the plaintiff, the person who files the case becomes the plaintiff, and the person who responds is called as the respondent or the defendant. So here she will be called as the respondent or defendant. Now the game starts. Once the allegation is made, you think this girl will keep quiet. She will make multiple other more allegations. So she will give 2 more allegations. Now the court will have to hear all the allegations together, decide each allegation, and on basis of all the allegation the net judgment will be given. So what the court will do, they will see issue, so they will frame issues. So what do the court do? They prepare issues. Issue 1, issue 2, issue 3, issue 4. For each issue, they will figure out who is right, who is wrong, who is right, who is wrong, and on basis of each of the issues and their particular verdict, then the final judgment is given. Final judgment is given here in the last. So all this is called as a decree. All this is called as a decree. So what is a decree? A decree is a formal expression of court, where the court conclusively decides the rights of a party. So it is a formal expression of court, means obviously court is not casually saying, it's a formal expression, where the court conclusively, finally decides one issue. So this issue, when they decide, they come to know that this girl is right. They'll come to know that the other girl is right. Here they'll come to know this girl is right in the end. And after all the decrees in mind, then the final judgment is given. Now this could be preliminary, it could be final, okay, temporary. One matter has been decided temporary, then in the final. So on basis of all the final decrees, the final judgment is given. So this is what. So now you understood what is a judgment. A judgment is obviously given. It's a you could say a summarization of all the things, all the decrees. So what is a decree? That each matter. So it's a formal expression where conclusively the rights of the parties have been decided with some or all the matters in controversy. It may be either preliminary or final. Done. Then, sir, what is a order? Let's see. What is a decree holder? Is a person who has won the case. The person who won the case is in whose favor the decree is given is called as a decree holder. Judgment dater is a person who lost the case, against whom the decree has been passed. So if you lost the case, then you will be a judgment dater. This is the terminology. So who won the case is a decree holder, who lost the case is a judgment dater. And finally, what is an order? So order is also a formal expression. Court is passing an order, means they're not joking. It's a formal, it's not informal, it's formal expression, but does not decide the rights of the parties. It is procedural in nature and does not decide the rights of the parties. For example, if I tell order, get the book and come here, it's an order. If the court tells that call this person, summon is an order. I'm summoning you, come here. The court tells that give your passport here, that is an order. If the court says that translate this into English and come, that's an order. Does not decide the rights of the parties, and it is not a decree. Decree is formal expression conclusively deciding a matter in controversy. So one controversial thing is finally settled, that is called as decree. Okay. Then comes interlocutory orders. Obviously interlocutory orders means during the pendency of the case some orders has been given, like interim sale, like let's say they both are disputing on a perishable goods. Now court will say that perishable goods will get expired tomorrow, so we can't wait till the judgment is given to, so we'll sell the goods, whatever money is received, then we'll give to the person who won the case. Now let's see, cause of action. What is the word cause of action? Means when did the default, when was the right, your right violated. Okay, so cause of action. Cause of action means what? If you let's say if there is a defamation, someone has defamed you, someone has spoken wrong about your reputation, so you will go to court. Now when you go to court, the court will ask that what is the cause of action, why did you come to court? The cause of action, you will say, sir, defamation. My name was spoiled. My name was written wrongly in the article. So cause of action is two things. One is you are telling that a right was there. I had a right of reputation and the right was affected and the right was infringed. Now we come to jurisdiction of courts. Sir, what do you mean by the term jurisdiction? Jurisdiction means, in technical words, if I tell you, it is a jurisdiction is the power of an authority to decide the case. To decide case. So let's say if a Mumbai, there is a murder happened in Mumbai. You go to Delhi police. Will the Delhi police take the matter? Yes or no? Delhi police will say you come to wrong area. The area is in that state. Go there. So obviously jurisdiction means they say we don't have the power to decide the case because we don't have jurisdiction. Go to the right forum. So jurisdiction means whether it is within your powers, the authority's power. So power to take up a case is called as jurisdiction. Again, power to take up a matter is called, of an authority is called as jurisdiction. Or jurisdiction could be on subject matter. For example, consumer case is a subject matter. So only consumer cases can go in consumer courts. Okay. Let's say if it is a family matter, it is a subject matter. So only in family court, only family related issues will go. Territorial, as I told you, in Mumbai case will go in Mumbai only. Jurisdiction over persons. So let's say NCLT can take up only corporate persons, or precedent cannot be taken in trial court. So sometimes jurisdiction depends on who the person is. Pecuniary jurisdiction. Pecuniary means monetary jurisdiction. Consumer forum, it is even district, then they're giving you national, they're giving you district, then state, and then national forum. So depending on the amount, you'll go to that forum. Another example, in small causes court only matters up till X amount is taken. Beyond that, you have to go to high court. Okay. So if it is exceeds the pecuniary limits, then you have to go to the. So sometimes if it is not within your pecuniary limit, a court cannot take up the matter. They will say it is not within my jurisdiction. Further, jurisdiction can be classified into original, appellate, and both. So original means the first application will be filed there. Like say your matter has gone to NCLT. So NCLT can originally take up because the suit will first be filed before there. Appellate means what? They cannot take up original matters. First matter cannot come. They can only entertain appeals. For example, NCLAT, National Company Law Appellate Tribunal. NCLAT cannot take up a fresh case. It can only take up appeals. Similarly, ITAT, Income Tax Appellate Tribunal, can entertain only appeal. It has only appellate jurisdiction. Whereas High Court and Supreme Court have appellate and original jurisdiction. Means writ petition can originally be filed there, and even High Court appeals can also, High Court can take both appeal and original petitions. Now we come to very important concept called as doctrine of res sub judice. What we are going to do? Doctrine of res sub judice. So you need to know both section 10 and 11. Res judicata and res sub judice. Okay. So what two doctrines we are doing? Section 10 and we are doing section 11. So we are doing res sub judice and we are doing res judicata. Res sub judice means what? Understand that court should not take up a matter which is ongoing in another court. Yes, common sense. If matter is going on in one court, which is and you are filing the same matter and same parties, the plaintiff and defendant, they are again filing in another court, then court will say that listen, I cannot take up the matter, I will stay the suit. So stay of suits is given. What does stay of suit mean? That we will say put a stay that we cannot take up the matter because it is already pending before another competent court in India. So they will pass the judgment. Why we should have multiplicity of cases? multiplicity of courts the matter is going on. Doesn't make sense. Now one another thing is, imagine if we took up also, that court also took and I also took up. Mumbai court also took and Gujarat court also took up, High Court. Both of them took up the same matter, deciding the same subject matter among the same parties. A passed another judgment, B passed another judgment. Again, there will be conflict of judgment and overburdening of cases and illogical thing. So simple res sub judice is, if a matter is pending before one court, then the same matter cannot be taken up before any other court. Now what is res judicata? Res judicata means no person shall be vexed twice. So if you read article 20, okay, it has also no person shall be vexed twice. That means if a matter is there which has been decided and punishment has been given. So matter is there, previously it was decided and punishment has been given. Then you want to file another case for the same act. Give punishment. They say we have already given punishment. How on the same thing we'll give you? So res sub judicata means don't punish a person twice. Okay, so you cannot vex a person twice. Vex means beat up, hurt, punish a person twice for same act. So now let's see, okay, how do I have worded it? Very, very simple, and we are done. So doctrine of res sub judice is under section 10. No court shall proceed with a trial which is substantially the same in a previous suit. So the res sub judice applies on the second court. The second court should not proceed with a trial if the matter is substantially, the issue is the same in a previous suit between the same parties litigating in the same title. Same title means plaintiff defendant, you are also plaintiff defendant, and it is pending in some court in India. If it is foreign court, then it can take up, but in India if it is there, it cannot be taken up. Done. Now when we see res judicata, what is res judicata? Under section 11, that there should be an end to litigation, no person shall be vexed twice. It prevents two different degrees on the same subject matter. Then constructive res judicata is those issues which you could have taken up but you did not take up. That also is said to be settled. So if I could have complained more but matter has already been decided, so they say, why didn't you say it earlier? So if I imagine a matter was there, it was settled and the person was punished, then I say I remember two more points. They say that is also ended. That is also ended. That is called as constructive res judicata. Matters which could have been taken for defense or attack in an earlier case, but you did not take it. So they will say that is also end. We'll treat it as a rule of convenience rather than rule of absolute justice. So we can't just sit and keep reopening cases. That two more points we found. We will settle the matter and consider it as, court is taking the easy path and ending it. Now, one thing, consent and compromise decree in between parties. Principle of res judicata shall not apply. See, a consent or a compromise decree is not a decision of court. I'll tell you. So where two parties have made a consent terms and they have come to the court. So court said, okay, fine, we did not decide. Now you only came with some letter that you all both have understood, have come to a consent term. It's acceptance to which the party has agreed. So we just agreed that you all both have made a out of court settlement. The court did not decide anything. The compromise decree, like between a lender and a creditor, they must have had some arrangement. They told the court said, okay, fine, you want to go ahead. But did that mean that the court decided it? No. So it is not a punishment from court. But when the court on the facts proved to a conclusion that the party intended that the consent should be having the effect of the deciding the question finally, the principle of res judicata may apply. The res judicata does not generally apply to consent. However, if the court found that the parties had said that none of us, this will be treated as res judicata and it is considered as a punishment only, then it may apply. So the discretion of the court. Normally Court will say that, listen, you all came with consent terms, you all, both of you all came having some agreement, I approved it. So then it is not, I am not punished you. That is what they are saying. However, if you all both come and say that this is treated as a punishment and from the letter, then the court may apply the rule. Section 11, this doctrine underlines the principle that no one shall be vexed twice for the same cause. However, it does not apply to consent orders but depends on the facts of the case. Normally it doesn't apply, but it depends on the facts of the case. Now we come to another important thing called as set off, counterclaim and equitable set off. What are we doing? All we are doing which is coming in the exam repeatedly. Okay. So set off, counterclaim and equitable set off. So three things we are doing: set off, counterclaim and equitable set off. So set off and equitable set off. So equitable set off is a type of set off. Let's see. Set off means what? That you had to give me 1 lakh, you had to pay me 1 lakh rupees, and I had to pay you 75,000. So ultimately you will pay me, we'll set off the 75,000. So whatever is plaintiff's claim and defendant's claim, whichever is common, will be set off. Another word for set off is it has been acquitted. Those things will be acquittal or will be settled or extinguished, and the balance amount will be paid. 25,000 now you will pay me. So set off is a reciprocal acquittal of claims. So called as reciprocal. So whatever is common will be set off and the balance order will be passed. So common sense, set off. Okay. So set off is a reciprocal acquittal of claim. It extinguishes my claim with your claim. For example, he has to give 1 lakh and this guy has to claim 25,000. So order 25 will be set off and only 75% order will, 75,000 order will be given. Very simple. Counter claim is, I am saying that the defendant imagine, so plaintiff is there and defendant is there. Plaintiff put a case. Who files a case? Plaintiff files a case, files case on defendant. Defendant has remedies. So defenses, defendant has certain remedy. What he can ask? One, he can ask for set off, that my claim and your claim should be set off. That's one remedy he can ask. The second he can say is a counter claim. In counter claim means I am claiming so much, now you have to pay me. So let's say it was a case of 1 lakh rupees. Okay. Now in counter claim what happens? I claim something where I say you have to pay me 5 lakh rupees. So now the plaintiff is like a defendant because now ultimately he has to pay more. So in addition to set off, I can also claim more. That is called as counter claim. Okay. So I will say that our debts has been set off, but he did me loss of business and opportunity. I want more money. He did defamation which caused the loss of shares. I want more money. So counter claim. Now counter claim comes from defendant to on the plaintiff. Defendant in a suit, in addition to his right of pleading set off, can make a counter claim against his plaintiff. It is a reverse claim. What it is a reverse claim. One party against another, both can be heard, and both these matters will be heard in the same proceedings. Equitable set off. In set off, what happens is money was known. You know the set off amount in terms of money. But what if I say I don't know in monetary terms? I know he caused me loss and damage, but I don't know exact amount. So equitable set off is a type of set off where you are claiming uncertain sum of money. In set off, you claim a certain sum of money, 75,000. I am claiming, and that is a set off figure. When I don't know exact, it's uncertain sum of money. Okay. Equitable set off is recognized in India. Now we come to temporary injunction and interlocutory order. So we've done interlocutory. Let's see temporary injunction. Now injunction, let's understand what is an injunction. Okay. Now we are understanding the term injunction. Injunction is a order of court. What is injunction? It is a order of court asking the party either to do or not to do something. Okay. So, and this injunction could be either temporary or it could be perpetual or final. Let's see. Permanent also they call it. Permanent. Let me explain. So for example, if there was an employee, he has been wrongfully removed. That employee went to court and he said that I have been removed. I was such a good employee. Only office politics have been removed. Court said, my God, till the decision is pending, till we finally decide the matter. So temporary means during the pendency of the case, comes in the initial part of the case, and perpetual is after hearing all the evidences, a final order is given. So if it is temporary till the decision of till the final decision, then it's temporary. But after hearing everything, then the final order is passed. So to do what we'll say, array, the employee has been removed, put him back. So example is reinstate employee. That the employee is a good guy, keep him back into the office. So it's the order of the court. You have to follow it. Or not to do something. Not to do something is, imagine for example, don't sell the property, don't sell or damage property till the final decision is given. So court can order you to do something or not to do something. Don't create one more flow. Okay, this is a not to do something. Now if in the initial stages they tell you on basis of prima facie evidence or temporary injunction, this can be reversed. After hearing all the parties and full evidence, then the court gives a final order. That final order is called as a perpetual order. That is then not reversed. It comes at the end of the case. So that's it. Temporary injunction. Now when we see summons, delivery of summons. Now summons, what does it mean? That whenever you give an application, then the court will summon a person. So normally who files a case? Plaintiff will file a case on the defendant. So plaintiff will go to the court and then the court will summon the defendant. Now court will tell the defendant by giving where he resides. They will send a notice, they will send a court summons, etc. Okay. And if he is trying to not take the summons, he goes away, he runs away. So a substituted summons is there where they will just stick at the door and it is a deemed delivery of summons. Okay. Substituted summons is when you're trying to avoid the service of summons, when you're not taking the letter of court only, then the court will just affix it, the order copy, on a conspicuous part of the house, a prominent entrance of the house. Okay. Then we see ex parte order and remedies against ex parte order. So this has been come in the past exam question. What is the ex parte order? When I am not appearing, if one of the party is not coming to court, court will pass a one-sided decision. So if the defendant does not appear before the court within the time prescribed, you think court is a joke, you're not coming before the court, then the court will pass a one-sided order in the presence of only one party. It's shocking, very rare they do it, but if you don't come, then the one-sided order will be passed. Now later the defendant comes and he realizes that something order has passed against him, then he will have to, what remedies he has. Defendant did not defend, ex parte order was passed, and now what remedy he has. So he will obviously go in appeal. He can tell the same court to review the judgment. He can apply for setting aside the review or the ex parte order, and can also, the suit can also be filed to set aside a ex parte order obtained by fraud, but no suit shall lie for non-service of summons. So basically you can have these remedies, go in appeal or review. This is the main one. Now very important, 100 times they've asked in the exam, reference review revision. What they've asked? Reference review revision. So reference is your section 113, 114 and 115. So these three are your key sections. Any of them can come. Very important. Reference means what? If a lower court feels at some point of law they want to ask the high court. So imagine how a junior can go and ask the senior. So what happens is at any time a subordinate court can refer a matter to the high court and the high court will then pass an order as it deems fit. So a matter can be taken and referred to the high court for its opinion. Review is like your in revaluation we give in an exam paper is there. So similarly, if a court has, if the in review is done, review is like a recheck or re-examination of the order by the same court. So we tell the same court that listen, please recheck your order. So they say we are mad over. We had checked our order and we had properly given. I say no, 3 conditions I have on MOD. Okay, MOD. So whenever the court will say why I should review my own judgment, so they will say 3 things. There is a mistake apparent on face of record. Some big mistake is there apparent on face of record. Any other reason. And D is discovery of a new fact which was not known at the time of passing the judgment. So during the case I didn't know this. Some new evidence I found and that is why I review your judgment now. The court will then make an order as it deems fit. And the third one is revision. Revision is like a writ of certiorari where the high court squashes, sets aside the lower court's order because it is erroneous, jurisdiction was not there, still they exceeded the jurisdiction, etc. So section 115, the court may call for the records. So the court calls for the records of a lower court, subordinate court, and sees and will revise the judgment if the lower court has not exercised the jurisdiction, failed to exercise, or has passed a erroneous order. Okay, so jurisdiction was not there, then they will take up the matters. Now suits by or against minor. Obviously, first who is a minor, who is not completed 18 years. But for House of Wards, that is where they take challenged children, Court of Wards, mentally challenged. For them, the age of maturity is 21 years. So normally we always see 18 years majority, not 21 for Court of Wards for mentally challenged. Okay. So then obviously they can also file a case, but they would be filing the case through their guardian. When the minor attains majority, then he can decide whether he wants to proceed with the suit by himself or he wants to drop the matter or he wants to change his guardian. That he can do. Then we come to summary procedure. Now what is a summary procedure? Is a speedy settlement of dispute. Summary means in short. In short we will settle the matter. So always remember that small matters etc. will be summarily tried, will be settled in a fast paced manner. Here fast paced, how it can be that leave to defend means a right to defend. So we say that it's a very small matter, I am not going to wait for years etc. So the plaintiff is there, he filed a case, we'll give the defendant exactly 10 days time. Okay, so if within 10 days the defendant is not come in such a small matter, we will pass a ex parte order. Okay, we will pass a ex parte order. Okay, and the summary suit must be filed within 1 year from the cause of action. Means if someone has not given you money, within 1 year you have to come and complain. Okay, so cause of action is 1 year, and then moment you file the case within the limitation period, then we will take up the matter. We'll tell the defendant within 10 days you tell what you want to tell, otherwise we'll pass a judgment. Okay. Now comes place of suing. This is section number 15. Now section number 15 says very simple that if I want to file a case, there directly I'll go to Supreme Court or I'll go to lower court. So obviously they say section number 15 that you have to, every suit shall first be instituted in the court of the lowest grade. So lowest grade first, court have to go first. According to section 16 of the CPC 1908, what does it subject to the pecuniary limit, the following suits relating to property shall be instituted in the court within the local limits whose jurisdiction the property is situated. Common sense. If now this is with respect to property. Okay, so let's say if the property is in Mumbai, obviously you will have to file the case in Mumbai court. So it will be given in the where the property is situated for recovery of movable property, partition of movable property, foreclosure of mortgage. Foreclosure means what? The creditor said that you could not pay the loan, I am selling it. So all will be where the property is situated. What is the main line? Where the property is situated. So all these property type of cases are there. Okay, immovable property, compensation for wrong on immovable property, recovery of movable property from all the above. So for example, even rent from immovable property is a movable property connected with the immovable property. So movable property is money. Okay, so all these issues with respect to immovable property will be filed where the property is situated. Simple logic. Section 17. Suits for immovable property within the jurisdiction of different courts. So now if a matter is coming within different courts, the suit may be instituted in courts within the local limits of whose jurisdiction any of the portion of the property is situated. So any portion of the property is situated. For example, let me give you an example. Now there is a dispute of a bridge. So bridge was here. Okay, a bridge is here. It goes from place 1 to place 2. And now the contractor and government, they are wanting to file a case. Now this is such a big bridge, or it is a railway track, or it is going into touching upon multiple jurisdictions. So that time they are saying that if it is multiple jurisdictions, then any court can take up the matter as long as even some portion is there in their jurisdiction, then they can take up the full matter. Okay, then comes section 18. Place of suing where local limits of the jurisdiction of the court are uncertain. Now we don't know the jurisdiction of the court is uncertain. Where there is uncertainty with respect to the jurisdiction of the court, then any court has satisfied the ground for uncertainty, record the statement and proceed with and entertain the case. So if there is uncertainty with respect, then they say any of the court, they can record the reasons why they are taking and they can take up the matter. The decree passed shall have the same effect as if the property was situated within the local limits of their jurisdiction. Okay, so this is just in case if some ambiguity is there in law, so they say anyone take up and close the case. Section 19. Suits for compensation for wrongs to persons or immovable. Where a suit for compensation for wrong is done to persons or to movable property, if the wrong was done within the local limits of the jurisdiction of one court and the defendant resides, the suit may be instituted at the option of either of the said courts. At the option of the plaintiff, it can be filed anywhere. So basically, suits for compensation for wrongs of movable property. For example, someone banged your car. So now where will you go? So you will go to the jurisdiction, two places. This is always the case. The plaintiff will have two options. Either he can go where the defendant resides or carries on business, or where the cause of action arose. So you can choose that the defendant resides or carrying on business, personally works within the local limits. You can file a case there. Okay. Now, just a few case laws have been given. Okay, in the new act. We'll just go through the crux. Okay. So this is from this supplement sheet. All the case laws which are there for your civil procedure code. Okay, let's see. So first case law, Yashpal Jain versus Sushila Devi, held that negative impact of excessive delay in civil proceedings lays down directions for expediting civil trials. The Supreme Court expressed concern over the judicial trial, issued 12 specific directions to ensure speedy trial and make stricter rules, etc. So in this case, they saw that there is a negative impact happening due to excessive delay. So that needs to be resolved, is what the court said. The Pata Subba Reddy, the judgment reinforces that delay in appeals cannot be condoned on merits alone, and there must be due diligence. Okay, petitioner filed an appeal with a delay of so many years. The Supreme Court upheld the High Court's dismissal, held that delay must be explained with sufficient cause. So extreme delay will be rejected. Then came concept. Cause of action refers to bundle. So we've done cause of action means all the essential facts which helped you file the case to get relief. National Institute of that section 10 applies only when the decision in a previous court was operate as will operate as res judicata in a subsequent case. The court was asked to stay proceedings due to a prior pending case. The court clarified the res judicata effect on an earlier suit is determining factors for applying section 10. So again, we have done section 10 and 11. You can mention that distinction between necessary and proper party. So necessary party is one without whom no effective order can be passed. It needs to be there, while a proper party helps in complete adjudication. Non-joinder. Now one line I want to tell you about this joinder. Okay, joinder or misjoinder. Pay attention. Misjoinder of parties. Now understand what does misjoinder of parties mean. So misjoinder of party means that if I have wrongfully connected any one party, okay, I have purposely taken the father of the defendant also. He says that it's a misjoinder, you have wrongfully joined me. Okay, so that is it. We've completed the entire chapter, including the amendments, which with just adding of case laws. Okay, so that is it, guys. I have done and completed the entire chapter. Okay, now remember one thing is, if you want to study more, you can obviously go for my dream badge. It gives you access to the paid lectures. You can complete your balance out. So in one day I can complete so many chapters. Just imagine you put in the efforts, how many chapters you can complete. Okay, so yes, I will be doing for other subjects also the marathon. I simply request you all to share it with your friends as well. Okay, so that is it, guys, for today's marathon. I've covered a lot of chapters, lot of marks also, and now I will see you all next in my next marathon. Do join my WhatsApp group. The links are in the description of the video. Thank you. Okay, thanks, guys. Great. Good night, everyone. Yuvashri, great. Okay. Glad you liked it. All I request you all is to share it in your WhatsApp groups. That would be the, your response. That's the thing I want from you all. Well, Ram, thank you so much for being so kind. I will sit again. Don't worry. This is not the end of the marathon. It's not my last marathon. Before the exams also I'll come. I'll ensure that I cover every chapter. Okay, so what I'm covering is all that is needed and what is asked in past exam questions also. Darshini, great. Okay, Catrioli, nice. Okay, thank you so much for all the heart. Good night, everyone. See you all tomorrow. Tomorrow's Fatima is taking a lecture, so do attend that as well. Take care. Good night.